Good afternoon. My name is Sherry Setfin, and I am the Seminole County Magistrate. And the way the process works is the county will present its case first, and it will present any evidence and testimony that it has. If you are here as a respondent, you will then be able to cross-examine any of the county's witnesses at that time, but you will not be able to present any witnesses or evidence of your own until it's your turn to go. Once the county has rested its case, it will then be your opportunity to provide any witnesses or testimony and evidence that you have. When both cases have closed, I'll make a decision here today. If you're here for a first-time violation, you are found in violation, you stand to have a penalty of up to $250 a day imposed for each and every day that your violation remains after the time frame that you're given for correction. If you're here on a repeat violation, you stand to have up to a $500 a day penalty imposed for any violation that continues after the time period that you're given to come into compliance. If you do have a copy of the agenda, please bear with us. We don't go in order. We have a rhyme or reason to the way that we call cases. If you are here, you will be called. I urge you to check in with the county if you've not done so already. And we'll go ahead and get started with our first case. So I'm going to call case 2465 CESM first. I believe that case is represented by attorney Greg Wilson.
Your Honor,
Yes.
please swear in.
Well, yeah, we will definitely swear in.
Okay.
Thank you.
I have it here. Yeah. So just, no? Oh, no.
What's this?
Do this now.
Yeah.
Wait.
Okay, okay,
It's got the index. That's the only thing that was missing.
okay, I wanted to ask the court to give us some time.
Okay, we're going to go ahead and swear in witnesses for this case. Do you have any witnesses that you need to swear, that you need sworn in?
I do, but I'd like to address the court first.
Okay.
Okay, my name is Greg Wilson, and I would ask for an extension of time for this hearing. And the reason is that I've applied to the Orange County, or the Seminole County Commissioners to make a determination as to whether you have jurisdiction, or not just you, but anybody here has a jurisdiction to determine this case because of the nature of it. It's a residential property, and the rules regarding the jurisdiction of this court says that they can't deal with non-residential. I mean, they only deal with non-residential property.
Oh, no, that's not correct. I deal with residential property every month.
Well, I'm referring to, so the record can show it then, Section 3, which is 3.21. It says Code Enforcement Special Magistrate Rules of Procedure. And number C, it says the special magistrate has jurisdiction to hear violations of all codes and ordinances of Seminole County with respect to non-residential properties or uses. And what we're dealing, I don't know whether you're not familiar with this, but I'll show you a copy of it.
Special Magistrate, if I may.
Sure, absolutely.
Deputy County Attorney Nasa Borkert. Mr. Wilson is failing to read the second sentence in the jurisdiction under 3.2 of our administrative code, which states that the county attorney or his or her designee, or the sheriff or his or her designee, is authorized to assign cases to address backlog or cases that are factually and legally complex. The county attorney's office has determined that this case before you is factually and somewhat legally complex for other reasons, not because of the violation, but for other reasons that you'll hear. And so the county attorney's office requested that you hear this case specifically pursuant to this section of the code.
Okay.
As you also know, under section 53.8 of the Seminole County Code, the code enforcement special magistrate may exercise any and all authority granted to the Seminole County Code Enforcement Board under chapter 53 of this section. So you do have the authority to hear any and all cases, and this has been specifically assigned to you by the county attorney's office.
Thank you.
Can I show this to the court and approach?
Sure.
Because all I know is what I read, Judge.
And what are you showing me?
It's called Seminole County Administrative Code. If it's on the back, it's just-
Okay, I'll just show, just so you can see what he's provided.
Yes.
I've already talked to them about it. They're aware of my position.
Okay, based on the information provided, the document you provided, and also the code sections that have been cited by the county attorney's office, I'm going to go ahead and accept jurisdiction of this matter, so I'm not going to continue. We're going to hear it today.
Yes, ma'am.
Okay, so do you have any witnesses that you would like sworn in?
Just my client.
Okay, so everyone who is going to provide testimony on either side, if you'll please stand and raise your right hand. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yeah, I do.
Okay, thank you. We'll go ahead and get started with the county's case.
Thank you. For the record, Mary Robinson, planner and code enforcement officer for Seminole County Development Services. This is a violation at 322 North Shadow Bay Boulevard, Longwood, Seminole County, Florida. The violation charge is from the Seminole County Code of Ordinances, Part 10, Maintenance of County Stormwater System, Section 270.414. The description of the violation is filling existing manholes and drainage pipe with concrete. This case summary is the initial inspection took place on April 23rd of 24. The notice was sent to respondent on July 8th of 24 with compliance dates of July 22nd, 24, and 8/7 of 24. Following up inspections were on August 9th, 24, and September 9th of 2024. The result of the reinspection was that the concrete pipe remains filled with concrete, and as do the manholes. This is the property record card from the Seminole County Property Appraiser's Office showing that the subject property owner does reside at this address. This is a posting of the notice of violation and an accompanying letter that stated that the violation had an additional time for compliance. This is the affidavit of service to Mr. Wilson, the violator's attorney. It was hand-delivered on September 6th, 2024. This time, Nasa Borkert, the county attorney's office, will continue the presentation.
Thank you, Mary. Nasa Borkert, Deputy County Attorney. The property owner here is being cited under Section 270.414 of the Seminole County Administrative Code. It states as follows: activities which are found to cause negative impacts to the interconnected stormwater system and are therefore prohibited include the following: vandalism, or otherwise causing damage to pipes and/or drainage structures. This section goes on to list other items that would violate this section of the code. However, here today, we're talking about specifically vandalism and damage to an existing stormwater system. As the following presentation will show, the property owner caused damage to drainage structures and pipe by hiring a company to fill manholes and a connecting pipe with concrete. The property owner has asserted to the county that she has a right to do this because the drainage facilities are located on her property. However, this argument fails because the definition of the interconnected stormwater system is as follows. The interconnected stormwater system is defined as all natural and man-made water bodies, dry lake beds, retention and detention ponds, pipe systems, and support structures located in the incorporated and unincorporated areas of Seminole County, or which are even located outside the boundaries of Seminole County and flow into Seminole County. So as you'll see by the definition, there is no requirement that the drainage facilities be located on public property or private property. It does not matter. It includes all structures within the county, which makes sense because the overall purpose of this section is to protect the system. And if the system's interconnected, then one blockage will cause blockage to the entire system and significant issues. We will discuss how the system works. The private system, in this case, is the private stormwater system in this development. We're going to discuss in our presentation how the system works so you can get a better idea and why the violation that's occurred here is particularly significant. Now I'm going to call up Joe Parrish, who is the Water Quality Program Manager. He is also the county staff member who first investigated the complaint that came into the county to provide his testimony.
Hi, good afternoon. I'm Joe Parrish. I'm head of the Water Quality Program under the Environmental Services Department. On March 13th of this year, So on March 13th of this year, we received a complaint forwarded to us from DEP in which they had received a complaint regarding a letter they had received. The letter from a homeowner in Shadow Bay indicated that they were advising they could close the pipe off and will have a drain problem that will back up on the road and properties. And so we were called to look into this. We notified buildings and looked into it as best we could remotely, but at that time we had no cause to visit the property. On April the 23rd, we received notification that the property was being acted on, that concrete was actively being poured. And I and my team arrived on site and were able to take pictures of the pour and the fill. And so this is taken from the right-of-way of the property and the company. And these are the two manholes that have been filled with concrete. At the back of the property, this pipe leads through the property to a detention pond, and that detention pond had plastic in the pipe to prevent the concrete from getting into the detention pond. So the pipe roughly runs from that bit of plastic all the way through the property. The border between the two properties and the adjacent property is roughly at the fence line between the two. And the pipe runs roughly from the back of the property there with the two gentlemen in the picture all the way to the front.
Special Magistrate, I forgot one thing, and I'll just interject here. The county has submitted its PowerPoint presentation into the record. It's also submitted a witness list and a binder, which has been given to the property owner. The binder includes an index and all the information that has been or will be referenced in this presentation. All the documents are included in this binder. The letter that was just referenced by Mr. Parrish, the letter from the violator to the neighboring property owners is tab 1. The report that was prepared by the Seminole County Watershed Management Complaint Form by Mr. Parrish is in tab 2, and so are the photographs that are in the PowerPoint. There's also some additional photographs in there. And then the notice of violation is tab 3 with the letter to the property owner and that Ms. Robinson mentioned. And then it goes on to photographs with Ms. Robinson we'll talk about now, and then some of the historical information for how the 20-foot drainage easement where the drainage facilities are located, how it came to be.
Okay, so as we go through this, if you'll stop in between and indicate for the record which tabs that you're referring to, like you just did, and you went through those few tabs, that would be great. And then I will ask you if you have any objections to what's being submitted, as once everything is submitted, that's how we handle it here. It gets all submitted first and explained as to what it is and who has done that, and then if you have any objections, you can put those on the record. But otherwise, that's how I handle my process. And I'll do the same with your information. I'll accept it from you. You will put it on the record, and if the county has any objections.
Can I cross-examine the witness?
You absolutely can.
Cannot?
You can,
All right.
yes. If you want to do that now, each witness as they come?
Certainly.
Okay.
Mr. Parrish, correct?
Yes.
Mr. Parrish, you said that you had a picture up here with some plastic and a pipe, and you said that was a pipe running from what?
I was told that was the pipe that runs from where the concrete is being filled in to the stormwater inlet that's located in the easement in front of the property.
And who told you that?
I believe the property owner.
My client here? Okay. Have you ever gone back again and see if there's a pipe there?
I have not.
Okay. So whoever may have told you that, you believe it's my client who just said no. We don't know that person, do we? Get a name and an address, take a statement from them?
I did get a name, and it was introduced as your client when she spoke with me on site.
Can I say something?
Not now. Okay, did you ever check out and see if that pipe was the pipe that came from the drainage system next door versus the one that my client was alleged to be filling in?
I did not.
Do you know whether that pipe, in fact, is from the next door drainage and behind the house next door on Lot 8 versus behind the house on Lot 7?
No.
Do you have a picture that we could see other than sideways to show us which house it's behind?
Unfortunately, I didn't take better pictures of that particular pipe and the perspectives on it.
Okay. So other than what you recall my client telling you about that pipe coming from her those drainage, what do you call those things?
The manholes?
Manholes. You have no proof that that pipe in fact went to those manholes or vice versa, correct?
I do not.
Does anybody?
I can't speak for the rest of the team at the moment. I'm only in the water quality program, so I don't have those kind of details.
Okay. So do you have any idea by looking at the manholes when you were there whether they were functional?
No.
Do you know anything about the history on Lot 7 as far as who put those manholes in?
I do not.
Do you know anything about a drainage system on Lot 8 next door, which is part of the same drainage system?
Your client indicated that there was a drainage system that ran through the plot next door and under her property.
And the what?
And under her property.
Okay, but your recollection is she said that one you looked at is the one that was coming from the manholes you inspected.
It was specifically indicated that the plastic was in place to keep the concrete from going into the retention pond.
I'm sorry, I don't understand. Say that again, please.
The plastic was put in the pipe
I got
to
you.
keep
I
the
didn't hear
concrete
the
from
word
going in.
plastic or understand it. Okay. Do you have a question? Okay, thanks, sir.
I have some questions. If you'll, in tab 2, if you will go to the first picture that you all showed originally. You can stop there, and then you can go through them. Where the fence gets, oh, go back to where you were? Okay. Where the fence gets taller, there's something on the ground right there. What does that look like to you?
Plastic sheeting.
Okay, and then the next picture is the concrete truck. Oh, wait, now I'm next. Okay, and now we're a little closer in this picture. What does that look like to you?
That is the back of the concrete truck with the chute. They were offloading the concrete into wheelbarrows.
Right, and then the piece of plastic, I think, is in the same spot that you identified as a piece of plastic?
Yes.
And then if we go to the next picture, I think you can see it. Is that, you believe, plastic? And then the next picture? Oh, that's not the one I have. There's another one.
Yeah, there's some additional pictures in here that weren't not up
Okay.
there, but
Maybe go, flip through a little more. Next. There. It looks to be the same type of material.
Yes.
Okay. All right.
Anything else?
Yeah.
Thanks, sir.
Again, for the record, Mary Robinson, Planner and Code Enforcement Officer for Development Services of Seminole County. This picture was taken on August 8th, the day that I posted the notice of violation at 322 North Shadow Bay Boulevard. The next slide. This is another photograph I took on the same date, August 8th, 2024, of
Can you-
North Shadow Bay Boulevard.
So is this, can you tell me where that is in relation to the property, the subject
Let
property?
me go back. Okay. The White House in the background is the subject property. Whoops, I went too far. And this was, the back of the truck was parked in the driveway of 322 North Shadow Bay Boulevard. I believe I'm looking south.
Which is the subject property?
Yes,
Okay.
yes.
And tell me where the subject property is in relation to this photo.
Trying to recall. Let me go to my picture so I can get some orientation. This might have been one of the side streets. I believe this is one of the side streets just a little bit past the subject property and to the right. So you can see this is taken looking, you can see the subject property. It's not the car that's in the foreground, but the further is the subject property on the left.
Okay.
So it's further down the street. And again, this is in the vicinity. I think the house in the picture is the next door neighbor. And I would like to say for the record that prior to coming out to this site on September 9th, from roughly July forward, there were numerous emails received from neighborhood residents that were submitted to Seminole County and also submitted to Seminole County Sheriff's Office Code Enforcement Portal that were forwarded to me.
And
And to others.
Mary, what were the subject matter of those?
The subject matter was of the flooding taking place in Shadow Bay, and that a drain pipe had been filled, and manholes had been filled.
So prior to the manhole being filled in April, had you experienced flooding like this in this area?
Myself personally, no. Was not witness to that or any of that information shared with me.
Okay.
Again, this is the subject property, 322 North Shadow Bay, right there at the White House. Again, just another for reference picture of the flooding and the subject property. And that will conclude my summary of the photographs. And I'll answer any questions if you so choose.
Ms. Robinson, you were only out there this one day, is that it?
I was out there 2 days, August 8th and September 9th.
Okay, had you ever been out there in years previous to this when it was flooding?
No, I had no cause to be out there in years past.
Okay, did you ever go behind that house that you've been looking at the pictures with the fence by it and see whether there's a drain going out into that little pond?
I did drive around the corner and see the retention pond, but I did not get out and investigate if there was a drain pipe there.
So you didn't know
But I've
whether-
seen drawings that do show the pipe going into the pond.
from which house, 8 or 9, 7 or 8?
In my opinion, it seems to straddle the property line. There's a 20-foot easement that runs between the two homes.
Okay, but
And we'll get into that detail.
when you say straddles the property,
I'm speaking of the easement.
I'm talking about where the pipe was, but was it behind lot 7 or behind lot 8?
I can't answer that.
Okay. I've been out there to look at it. If I say it's behind lot 8, would you believe me?
Objection. Relevance.
Relevance. That's what we're talking about here, whether there's an.
Well, the fact of whether or not I believe you is not relevant.
Well,
Well, are you asking the questions or are you testifying?
I'm asking the question the
Okay.
way I'm asking them. ma'am.
So let's just ask the questions.
Okay. Would you believe me if I said it was behind lot 8 instead of lot 7?
I would take your opinion and consult with professionals in my office to get an accurate determination.
Okay, has anybody that's testifying today seen it and know which lot it's behind?
I can't answer that.
Okay, are you aware that on lot 8, there apparently for years was a drainage system going out into that little pond behind?
You can say no.
No, but the violation is filling a pipe.
Well, if the pipe had no function, and if the pipe, some of it was on her property, not on the easement,
Can we get order? I'm sorry to interrupt. They're laughing and I can't hear what he's saying. This group of people.
I'll keep order, okay, ma'am?
Thank you. I'm sorry.
John, do you want me to repeat that question?
Yes, please.
Were you aware that on Lot 8, there was a system, stormwater system that went into the pond out back?
No, sir.
Okay. Were you aware that on Lot 7, those particular drainage bins and the pipes were not going anywhere? They were hooked up to nothing?
No.
Okay, does anybody in your investigation have any information about the drainage system that's gone down Lot 7 for some 20 years or more?
Yes, and that will be presented
Who
in
is
this
that?
case.
Who would that be?
Our development review manager.
Okay, are you aware in talking to your development review manager that in fact the drainage system was on Lot 7, not Lot 8?
Yes, it was on Lot 7.
Your person you're referring to knows that?
I believe he does, but I think that's a question you need to ask him.
Well, I will, but you're the chief investigator, and I can find out what you know, I think, if you know it. Did you know that one of those drains that was filled in with cement was partially, if not half, on my client's private, personal property, not part of the easement?
It's my understanding the entire system was in the easement.
Okay, so if I told you that, you'd say I'm wrong, is that correct?
I wouldn't say you were wrong, but we would have to do a field verification.
Okay, well, that might be worth doing. Are you aware that well, let me ask you this. Was there any type of a plan or system filed with anybody, to your knowledge, about that stormwater drain system, whether it was on 7, 8, or both?
Yes, I think with the original development, there was some plans that were
Have you looked
submitted.
at them?
Yes.
And what do they show?
I'm going to defer to our development review manager to answer that. He's a professional engineer.
Okay. Are you aware whether any permit was ever pulled by anybody to put a stormwater drainage system on Lot 7 or 8?
That I can answer, and I have been informed that there was no permit pulled by the contractor to install the pipe.
Are you aware that the drainage easement that the people in the condo association are claiming they have, that particular drainage easement is completely non-specific about what responsibility belonged to whom on that drainage easement?
Are you talking about the drainage easement between lots 7 and 8 of Shadow Bay?
Yes, ma'am.
Well, you said the condo, so if
Well, the
they're
condo
single family.
association has an easement, correct, on 7 and 8 for drainage purposes, 10 feet on one, 10 feet on the other, correct?
No, I don't think that's correct. I don't think it's the condominium association.
Well,
But there is an easement shown on the plat, and there is a deed that is referenced.
Okay, whoever has it, whether it's condominium association or back at the time it was given, it was another name. There's a, some type of an explanation as to what's being given, correct?
Yes.
And is there any explanation as to who has what responsibility where, who can do what when, or who has the authority to do anything?
I don't recall seeing that.
Okay, doesn't it in fact just say drainage easement?
Yes.
Okay, what does that mean?
Drainage easement is there to move potential water.
Okay, who's going to take care of it in case there's problems?
That is a good question. So it needs to be addressed, who would take care of it?
And there was no permit drawn to even come up with that, correct?
Correct.
And that's what you're trying to enforce, correct?
We're enforcing the violation of a drainage stormwater system
Okay,
of our code.
which is non-specific, correct? Doesn't say what it means.
What means a deed? Are you
What a
speaking to the
drainage
deed?
easement means. Does it mean Lot 7 and Lot 8 had to take care of it? Did it mean this condo association
Well,
had to
you're
take care?
talking
Let me
about what
finish.
does drainage
Let me finish,
mean, and then you're
let
talking
me
about
finish, please.
maintenance.
Ma'am, I'm trying to explain it to you. You're interrupting me, please. Is there anything anywhere explaining what that drainage easement means?
Objection. Relevance. I don't understand the relevance of this line of questioning. The violation is damaging a stormwater system. A manhole and a stormwater pipe is part of a stormwater system. Who legally owns it, whether it's public or private, that is of no significance in this matter. Damage was done to the manhole and the stormwater pipe. It has resulted in excessive flooding, and I do not see the relevance of this line of questioning.
Do you have a point?
Well, the point is, somebody at some point gave a drainage easement to somebody.
It was by the plat, obviously.
Well, a plat isn't a deeded drainage easement. So
No, but it's platted, and the plat would control. So let's move along. If you have something else that you want to ask related to the drainage that is in violation, or that they're claiming is in violation, then I'm fine with you asking that. But she has indicated to you that she doesn't know how the easement is granted. So for you to continue to ask her questions about how the easement's granted, she has said she doesn't know. So if you want to ask someone else the questions, that's completely fine, or if you want to move on to something else with this witness. But I can tell you that the easement's granted by a plat, and I can tell you that without seeing anything. So,
If you're correct, the law is a plat can't grant an easement.
cannot what?
Plat cannot grant an easement.
Really?
Yes, ma'am.
I've never heard that before. Do you have that law with you, that a
No,
plat
but
can't
I-
grant an easement?
I'd be happy to give it to you.
I would-
It's
yes.
got to be a deed.
Okay, I'd certainly like to see that, because
I'll
I
get it for the court.
was unaware of that.
Hold on, let me make a note.
Okay. Do you have any further questions for this witness?
Just 1 second. Who is the person you said that would know the answers to these questions, so I can make a note of it?
Our development review manager has details on the drawings and the placement of the pipe, and et cetera.
Is he going to testify today?
Yes, he is.
What is his name?
Vladimir Simoneski.
I know Vladimir. Thank you. Thank you, ma'am. That's all I have.
Thank you.
And I apologize, for the record, Ms. Robinson was talking about tab 4. That includes the flooding, pictures of the flooding. Tabs, in the next items on the PowerPoint will reference which tab shows which plan. The only one that isn't referenced there is number 5, tab number 5, which includes surveys of Lot 7 that were discussed with the county by the property owner that she obtained for her property
Okay,
at previous meetings up until this hearing.
okay.
Now Vladimir Simonovsky is going to come up and discuss the history of this property and the prior permitting and approvals.
Good afternoon, everyone. For the record, Vladimir Simonovsky. I'm a professional engineer, development review engineering manager with the Public Works Department with Seminole County. So I'm going to present some of the technical information on this. They will relate to some of the questions that Mr. Wilson just had. And this is going to be related to some of the plot and the history of the project and how it started from inception to final completion. So these are the findings of the Development Review Engineering Division. What you see on the slide is basically the Shadow Bay community was planned in 3 phases or 3 units, as they were called on this plan. Unit 1 was built on the south side of the community main entrance and consists of single residential units. Unit 2, which is presented on the slide, which is referenced in tab 13, was built on the north side of the community main entrance and consists of townhomes that were built in 2 phases. Phase 1 to the south and phase 2 to the north, and they're divided on that slide. Unit 3 was built west of the Unit 2, which is shown on the right-hand side of the slide where the ponds are. And it was planned to consist of 4 condominium buildings and to be built in 1 phase. Only 2 of the 4 buildings were constructed, and the remaining of the land was developed into 10 single residential units, as we will get into that. The stormwater management system for the Unit 2 and 3 was master planned and constructed as part of the Unit 2 development in 1984, and that's being shown on the slide, tab 13. This system consists of 2 subsystems, which is the stormwater conveyance system, which consists of pipes, wells, inlets, etc., and the stormwater treatment, which consists of detention ponds. And there you can see them in the right-hand side of the slide. The rainfall runoff from the west drainage subbasin, which is approximately 12 acres, which is entirely consisting of the second phase, the north side of the development, and partially of the first phase, which is the south side. is conveyed to the north detention pond, which is tract 8 depicted on the north side, on the right-hand side on that slide. And this is recorded, and this is through 24-inch pipe located in the 20-foot wide drainage easement. Now, the drainage easement is depicted on the Unit 2 as-built plans from June 1984, which is exactly the same slide, and recorded in Plat Book 45, page 81. Can we move to the next slide? The same drainage easement is depicted on the Unit 3 construction plans from the February 1985, shown on that tab 12, the next, on the same slide, and lakeside of Shadow Bay Community Plat from September 1985, which is going to be the next slide. So that's the plat for the lakeside when it finally received the name.
Vlad, can I ask you a question here? The highlighted area that's shown, can you explain what that is, the two highlights? And there were areas highlighted on the prior slides too.
The
Can you
highlighted
highlight-
area on all of these slides depicts the 20-foot wide drainage easement.
Okay, and is it your opinion that this 25-foot wide drainage easement that was shown on the first as-built construction plans through this period of time right here is the 20-foot drainage easement where the outfall is for the Shadow Bay Club or Unit 2?
Correct. That's exactly the same location, and it's depicted on all these documents, and I'll get to it as we complete the rest of the slides. Again, this is from the 10 residential units that were developed as part of the Unit 3 after it was subdivided. So again, the same drainage easement is depicted on the Lake Vista at Shadow Bay preliminary plans from February 1992. So this is 7 years after. And the Lake Vista at Shadow Bay plat from September 1992, which is going to be the next slide. That's in tab 10 and tab 8 for the record.
Vlad, can I ask you a quick question here? So how did we get here? Because previously on this plan, it shows this area as being all condominiums. There's approximately 4 condominium buildings in the original condominium plat. And then we moved to the preliminary plan, as you said, approximately 7 years later, which shows 10 single-family residential lots. Can you tell me what happened here?
Correct. So as I stated earlier, this was planned as to be 4 condominium buildings to be part of Unit 3. Only 2 of the buildings, the one on the south side, were constructed in 1985, and then the remaining of the property was developed subsequently 7 years later into a different phase that became eventually Lake Vista at Shadow Bay, and it was replatted from the original plat for the lakeside to become Lake Vista into 10 single residential units. So subsequently, that 20-foot drainage easement that was shown on the previous plan, on the previous development, being between building 3 and 4, I believe, now it's between lot 7 and lot 8 of the Lake Vista development. That is also highlighted on those 2 slides.
And Vlad, can I ask you, on this slide in tab 8, the 20-foot drainage easement that shows here, does that reference an OR book and page that established the easement?
Correct. That's what I referenced, recorded in Plat Book 45, page 81.
I mean the reference for the drainage easement on the plat.
Yes.
Yeah. That OR
Yeah,
book and page.
clearly
Yeah.
referenced that, yes.
Okay.
There was some, and we can expand on this, I know Mr. Wilson's going to have a question probably on this. There were 2 labels on that plat, one which was on the north side label that calls for a construction maintenance easement during the construction time, and on the south side there's a label for the drainage easement, which refers to the page 45, book 81. So that's the same, exactly the same area, the same parcel.
Vlad, can you just look at tab 8 for me and then read the OR book and page for the 20-foot drainage easement? I'm sorry, it's pretty small in this picture. Can you just read that for me?
I'm sorry.
It's okay.
It says 20-foot drainage easement per OR book. is that nine?
Is it too small?
1948, I believe, 1718. And 1718 is actually the third page when we did the title research of the 3 pages, which starts with 1716. 1718 is referenced because the legal description for this particular section is on page 1718.
I'll also note here for the record that the deed that was just referenced by Mr. Simonovsky is included under tab 6 of the binder that you were given.
So in order to verify that, the county surveyor sketch of the legal description, which is going to be the next slide, please, of the recorded drainage easement in August of this year, 2024, confirmed that the drainage easement is at the same location as all previously presented documents on the as-built plans, construction plans, and plats. So, based on all of this, the damaged section of the stormwater conveyance system makes the stormwater management system for the west drainage sub-basin non-functional, which is the one on that slide that consists of exactly 11.9 acres, and we run it approximately to 12 acres. That's for
Vlad,
illustration.
If I can just interject here
Go
for the
ahead.
special magistrate. Special magistrate, this slide and the following slide are not included in your binder. They're just included in the PowerPoint presentation.
Okay, I wasn't aware of that. Okay, so the damaged section of the stormwater conveyance system makes the stormwater management system for the west drainage sub-basin only non-functional, therefore causing the presented extensive flooding of the affected part of the Shadow Bay community. This damaged section appears to be partially repairable and will require partial removal and reconstruction based on all the previous pictures that were presented. These are the findings of our engineering team, and I'm presenting this as a manager of the development review engineer.
Vlad, I have a quick question for you to verify. The original as-built system that was put in, does the county have permits for that as-built system?
That was permitted, I believe, in 1981. We checked the records. There were no St. John's permit because St. John's was established in 1983. So we only found the records of the as-built plans, which are, again, referring to the previous construction plans.
Thank you. That concludes Mr. Simonovsky's presentation.
I'm ready to any questions you may have.
Oh, yes. Good afternoon, sir.
Good afternoon, Mr. Wilson.
On your last question and answer, if I understood you correctly, there's no permit for any drainage system on lots 7 and 8 that you could find. Is that correct?
So the system was obviously permitted by the county, probably sometime between 1985 and 83.
How do you know that?
We don't have. Yeah, we have the as-built plans. I cannot answer that question, I'm sorry, but
Okay, I just wondered. So there, just so I understand your answer too, Lot 7 and Lot 8, there, to your, at least you do not have any permit for any type of drainage system. Is that correct?
well, that was part of the master plan, and it was clearly shown on the plat. So it's recorded in the plat.
It's recorded as a drainage easement, is that it? I mean, that's it, correct? I mean, there's no explanation to anybody, is there?
I'm not clear of the question, if you can please repeat
Well, a
that.
drainage permit, you could probably ask everybody in this room, and all they might say is a drain, you can use a drain. They're not going to know who's responsible for building it, who's responsible for maintaining it, whether you need to use 7 and 8 both, or just one versus the other. It's just a drainage easement, subject to anybody's interpretation in this room or otherwise. Correct?
So since there was no St. John's permit at the time, which is the water management district for this region, the drainage was part, there's no separate drainage permit. The drainage was part of the overall development permit.
Okay. But was there any written document anywhere to your knowledge that describes who's going to do what on those pieces of property? Whether the owner has a responsibility, whether the development has a responsibility, or whether the county has a responsibility?
So the county definitely was clearly stated that the county has no responsibility for it.
Okay.
The developer was going to develop that as part of the master plan so he can serve the Unit 2 before Unit 3 was developed,
Okay.
correct? So I think we are clear on that, if I'm answering your question. right?
Okay, well, you're not answering my question, because I want to know whether I can go somewhere
Okay,
and
so the
look at
county, the
something.
county was not involved.
Wait, if you're going to ask him questions, let him finish his answer. If you have a different question,
Well,
then,
I'm trying to explain my question because he was misunderstanding it, Your Honor.
oh, well, he didn't say he
I-
misunderstood it. He
yeah, I
was
don't-
providing you an answer. So your court reporter isn't going to get the over-talking. But if you want a different question asked, then you can ask it.
Okay, I'll ask it again then, maybe a different way.
Okay,
Is there any written document anywhere that any of us in this room or otherwise could go see that says what that drainage easement means, whose responsibility it is to do what?
So the responsibility is determined.
Just answer the question, is there a document?
There is a document with the plat, with transferring the, again, this is a legal question, but I'm going to try to answer your question. So typically what happens is the developer is going to build the development, correct? And after the plans are accepted, then it gets transferred to the HOA. The HOA at the time was Shadow Bay Club. When the Unit 3, this is from our research, when the Unit 3 developed, that particular drainage easement was transferred to Unit 3, which is Lakeside at Shadow Bay.
Okay,
And then when the second phase of Unit 3, which is Lakeside, the 10 residential units, were developed, there is a document that transfers the drainage easement from Lakeside to them. So the Lakeside only retained the 2 retention ponds.
okay.
So I think that's what your question was,
No, sir. Let me try again.
okay?
Does anybody possess a written document that explains exactly the responsibilities of a drainage easement? Are you done? I mean,
No,
y'all are
we-
talking to each other. That explains what that means. What drainage easement means in this particular set of facts. Is there any document that says that? Do you understand my question? If not, I'll try and be more specific.
You can say no. If you don't know, say you don't know.
I don't think I understand your question. If you're asking me about the definition of a drainage easement, the purpose of a drainage easement is to convey runoff from one point to another through particular properties.
Will you agree that maybe a whole lot of people in this room could have different answers to that question? That's
Objection,
why-
relevance.
Pardon? Who objected?
I objected.
Oh, I didn't see that.
Relevance. So I objected relevance because what everyone in this room may feel what a drainage easement is not relevant to to the question at hand, and frankly, maintenance responsibilities of what is included within this drainage easement is not of concern either for the violation. The violation is that the stormwater facilities here were damaged.
Okay, the reason it's important is because it could have been done on one property versus the other. It could have been the responsibility of who knows who to maintain it, put the pipes in, change the pipes around. I'm just asking if anything like that exists to your knowledge.
So to my knowledge, the Lake Vista HOA dissolved at some point. So, which means that nobody was maintaining that drainage easement for some time.
Were they supposed to maintain it? Is that in writing?
Yes, that was the transfer from Lakeside to Lake Vista when Lake Vista was developed in 1992.
But part of the transfer was that one person's supposed to maintain it versus another? If so, where's that document that says that?
I am more equipped to answer these questions because I will go through the title. Mr. Simonovsky is our engineering person. He should really be only asked engineering questions, not maintenance questions, and what the title documents say, which I will be able to address. I've been sworn in. I will take my hat off as the attorney and speak as a witness at that point because I reviewed all the title work for Lot 7 and 8 and some other surrounding properties.
Well, if he can't answer it, he can say he can't answer it, John.
He has.
I don't think so, but I'll accept that. Let me ask you this. Do you know whether at any given time that the main drainage down to that pond was on Lot 8 or Lot 7?
So to my knowledge, the pipe, there's a report from an independent engineer that was hired by Century Management in 1993 that the pipe was installed on the north side of the drainage easement, which is inside the drainage easement. And this happened, this was a knowledge when they built, actually they started building the homes in Lake Vista, which is the 10 residential units. So basically the pipe was literally on the borderline under the foundation of the house that is built on Lot 7. And there was a 24-inch pipe that connected the inlet that is in the private right-of-way to the pond,
Okay.
which is in Tract A.
And was that in use to your knowledge when you went out and examined the property?
I personally did not examine the pipe. The Public Works Department sent a team, and they investigated this. And what was discovered is that apparently that pipe was severed before the first concrete manhole. It's actually a plastic manhole, I need to correct myself. And there's no record of when that happened. So the pipe was basically severed under the house, it was grouted, and it
Severed?
was rerouted
Excuse me, are you saying severed?
Yes.
under the house.
Okay, I'm
Correct.
sorry, I didn't understand that word you were using.
No. Yeah,
Okay.
absolutely. And then it was rerouted to where it's located now.
Which
Right
is-
under the white vinyl fence, which is the middle of the two properties.
Okay. Then, did you find out in your investigation why these manholes that were filled with concrete by my client were even in existence if the drainage pipe was between Lot 7 and Lot 8?
Well, the drainage pipe is there even now. The one that was functioning, that was providing the conveyance, is the one that was being filled with concrete, which is the section between the two plastic manholes, ADS manholes, that we can see on the slide there.
And it would be basically under that fence line, is that what you're
It's
saying?
under the fence line, correct.
Okay, and it drains out where?
It drains back into the pond in Tract A.
Off Lot 8 or Lot 7?
It doesn't matter, because there's a 20-foot drainage easement.
I
So
didn't
it's
say-
10 feet wide on each
I didn't ask you if it
side.
mattered. Do you know which one it drains out of?
Well,
It's 8, isn't it?
so I haven't been back there because it's not accessible. I didn't have the equipment, but I've been investigating a long time this case, and everything points out that the pipe is within the drainage easement.
Okay.
Now, is it slightly a little bit behind lot 7 or lot 8? It's within the drainage easement.
I'm asking you the actual drain out into the pond. Where is that located in the back?
It's in line with the white vinyl fence.
Okay. And is there any drainage pipe from that pipe you were talking about that was underneath where the house went?
That pipe has been severed and filled with grout.
Okay, so nothing's working in that pipe.
Nothing is working. There's no water, there's no conveyance, runoff conveyance going through that pipe.
Okay, well then, please explain to me why these two things that were filled in with concrete that were over on my client's property, even though one is in the easement and one isn't entirely in the easement, why they were there?
As I said, because of that 1993 report, that the developer had a concern, and the Century Management, which was the management company for the HOA, for the previous HOA, that had a concern that that pipe being under the foundation could potentially, over time, damage the house.
Okay, are you aware that the one pipe that's partly on my client's property, not on the easement, had a pipe heading out towards the one under the house?
I'm not sure on which one you're referring. Are you referring to the one between the inlet in the private right-of-way, going into the first manhole in front of the house?
I'm talking about, there's two manholes that are over on my client's property, Lot 7.
Correct.
One of them's partially outside the easement. Are you aware of that?
Do we have a picture that shows both of them?
So if I can, if I may, under tab number 5 is, okay,
Sorry.
We can though, can't we?
yeah.
We can use it.
Would you like it up here, or would you like to just look
I think I can look from my book, but I think it might be a good idea to put it up.
Mr. Wilson should have this because it was brought to us by his client.
Brought it.
So Vlad, if you could just explain, is there a way to make it closer, or is this the closest we can get? There's a zoom?
Is there a zoom?
You can zoom in. Is it zooming? Yeah, there you go, okay.
Oh. I think she did tell you more. I didn't know what it was.
Vlad, maybe if you can just explain what's on this.
So over there on the right-hand side, there's a note pointing into the first manhole coming off the street. That there's a underground portion of structure that is approximately 1.2 feet outside of the drainage easement, of the 20-foot drainage easement.
So Vlad, maybe you can explain, starting from the inlet there and what is
Do
shown
we
on
have
this
a
survey?
Pointer?
You can point with your finger or your pen on the projection.
Okay, so this is the inlet that is in the private right-of-way. That takes the water from the road, and the original pipe was going straight back into the pond, which what I said earlier, it's on the borderline on the north side of the 20-foot drainage easement. That was eventually relocated at some point, so that section of the pipe here was severed and it was grouted. These two manholes were being installed to reroute the flow and to take the pipe now exactly where it was supposed to be originally constructed, in the middle of the drainage easement, back into the pond. So it kept the same function. Is that?
Let me point something out if I can.
So the manhole that you're referring to here, this is the one you're referring to. The manhole Mr. Wilson is referring to here, there is a note over here on the right-hand side that talks about 1.2 feet encroachment into Lot 7 outside of the 20-feet drainage easement.
Right.
But still on Lot 7 and still part of the overall interconnected stormwater drainage system.
Correct.
Except it's partially on Lot 7, not the east.
Does it help drain Lot 7?
Does it help? I'm sorry?
Drain Lot 7 as part of the overall system?
Yes, Lot 7 is part of the overall system.
No. Does it help, does that manhole help drain?
No, it doesn't, because it only serves to convey the water collected in the private right-of-way.
No, but does Lot 7 drain to the private right-of-way and into the system?
I'm not certain about it. I believe partially it does. The frontage from the front of the house towards the road, the back of the house, I believe, drains to the back.
Just sheet flows itself
Correct.
into, so all of those lots along there are interconnected into that system. So part of those lots, if to the extent they drain forward naturally.
Correct.
They go into the drains in the road.
That's correct.
And then to the extent they drain from the back, they drain into the pond
Directly into the
directly.
pond. That's correct.
But it's all part of the overall interconnected system, all of those lots.
That is correct.
That's all I have, Vladimir, thank you.
Thank you, Mr. Wilson.
Because he doesn't know, she doesn't know why you could try to have a
I think we just will have to restart, so as soon as it doesn't count down, we can put a copy of the slideshow up here if you want to do that while we're waiting for it to boot up.
Okay, I just have a couple, just one, oh, no, actually, I don't have any more further. We covered the one item I was going to ask him about. You're
Okay.
finished. Thank you, Vlad.
Thank you.
Unfortunately, I turned that completely off and did not mean to. I was just trying to shut the projection off and put it back to the PowerPoint. So it's going to take a minute to start back up, but. Can we put it,
Yes, it has to. It should
Okay.
do a document as soon as it finishes the slide.
okay.
And then it'll.
Okay. We can put that here and then start it back up, but I can start. It's not, I don't have any projections or anything to use. So to conclude, I'm going to briefly discuss the ownership and development history of the subject property and the easement. As Vlad stated in his testimony, the 20-foot drainage easement originated from the warranty deed that's in tab 6 that was originally conveyed by Shadow Bay Limited to Southland Limited LLP, and it conveyed the condo property. So it conveyed the condominium property, 6+ acres, and it was subject to a 20-foot drainage easement. That's the language of the warranty deed. Likewise, the second conveyance that occurred after that occurred from Southland Limited LLC to Shadow Bay Inc., and that was in 1985. The first conveyance was in 1981. That's also in tab 6. That included the same language of the 20-foot drainage easement. After the conveyance, that's when the Lakeside at Shadow Bay condominium plat was recorded. As Vlad showed in his presentation, that included the 20-foot drainage easement, showed it on the condominium plat. And then the property was subsequently conveyed referencing the condominium plat. Phases 3 through 4 of the condominium plat were replatted, as Vlad said, to 10 single-family lots within the Lake Vista Shadow Bay plat. And as we talked about, that plat specifically includes a 20-foot drainage easement and references the warranty deed, the original warranty deed. That was in 1992. Subsequent to that, all conveyances for Lot 7, which is the subject property, were conveyed referencing the Lake Vista at Shadow Bay plat. There were no documents in my review of the title documents, and as I stated earlier, I reviewed the title reports for Lot 7, Lot 8, and in the Lot 7 and the Lot 8, frankly, title information, there were no documents or language in the title work that would have released or terminated this drainage easement. So it's the county's view that there is a valid 20-foot drainage easement on the property, that the maintenance of the easement or the rights to that easement are probably still held by the original developer. I did not find in my title review any assignment of rights for that easement to the Shadow Bay Club HOA, which conceivably that's the way it should have occurred. There were a number of other conveyances, assignment of rights for easement rights over roads. All the roads in the private system within these plats are private, and the drainage system. There were no assignment for this specific easement. With that being said, the maintenance and the easement itself, as I indicated earlier, are really of no concern for the violation. The violation is damage to a drainage structure, to multiple drainage structures, and under the code, that is a violation of the code because it is an impact on the interconnected stormwater system of the county. This system does not require it to be public or private. That makes much sense because you cannot have people going into facing these things and causing flooding and impacts to neighboring properties. So given the foregoing, the county is recommending that the special magistrate find the property owner in violation of section 270.414 of the Seminole County Code and order that the property be brought into compliance within 5 days of this hearing. The actions required for compliance, as Mr. Simonovsky stated, are to repair or replace the damaged manholes and drainage pipe and connect them to the existing system. The staff is recommending 5 days to comply, as the applicant has been given over 2 months to correct the significant damage that was caused and has not done anything to rectify that. Further, as shown by the photos provided in this presentation, significant flooding on the subject property and in the surrounding neighborhood has occurred since the property owner damaged the system and continues to result in standing water in the area. The residents of the Shadow Bay community have contacted the county on multiple occasions with complaints about flooding and stories of significant impacts to the welfare of the residents within that community. Finally, staff is recommending a daily fine of $250 per day due to the magnitude of the flooding that has occurred, and the health and safety concerns it presents to the neighbors and the surrounding areas. Those impacts include standing water for days, inaccessibility to homes, damage to property and roadways, and the proliferation of mosquitoes. While this may be the property owner's first violation, as I indicated previously, the property owner has not taken any steps to abate the violation. This concludes the county's presentation on the case. However, the county does request time for rebuttal after the property owner has presented her case, and I'll stand for any questions.
Okay, and you had previously asked for the notebook to be submitted into evidence along with the electronic case file in this matter. Is that correct?
Yes, and the PowerPoint.
The electronic case,
Oh.
okay.
Yep.
You've been provided with both of these items. Each one of the tabbed items have been discussed in the testimony provided by the county's witnesses. Do you have any objection to the information contained in the binder and the information in the electronic case file being submitted into evidence?
The only objection I have is they don't have anything that really tells what a drainage easement is or whether they're functional at the time, even today.
Well, I think their evidence does have that. I think their testimony provided that, but I didn't ask what lack of evidence you object to. I asked if you object to the evidence that they're trying to present. If she objects, she needs to state on the record exactly what she objects
Yes,
to.
ma'am. Can I speak through for a second?
Sure.
I don't object as far as they have. I do object that they do not have enough evidence to
Okay, noted.
comply.
Okay, noted. I will accept the county's binder of evidence along with the electronic case file into the record. Is this the close of the county's initial case?
Yes, that's correct.
Okay.
I didn't know if I needed to answer any questions by Mr. Wilson, but I'm available.
I'll ask you some questions. Do you have any information in your investigation that would determine who put those manholes in on Lot 7 and whether they were connected to anything?
No.
Are you aware that my client could get nobody at the homeowners association to talk to her, period, about those manholes before she did what she did?
Am I personally aware of that? Your client, yes, has relayed that to me in
Okay.
previous meetings we've had.
Okay. And do you have any information that would show that what she related to you and what I just asked you is incorrect? For example, do you have any information or know of any information that would show that the pipes went out of these manholes and were broken, and one of them went to this under the house, which is outside the easement? Do you have any information that that isn't correct?
No, I believe Mr. Simonovsky explained that.
Okay. But do you have any information that the other manhole apparently wasn't connected to anything because it was full of water?
I don't have any personal information of that,
Okay.
but manholes are typically have water in them.
Not to the top generally, if they're functioning. Do you have any information who was in charge of repairing any system that was on Lot 7 or Lot 8?
No, I just know it's not the county's responsibility. The county's my client.
No, but if it's flooding her property, it isn't her responsibility either, is it?
To maintain the
Correct.
system,
Correct.
Is it her responsibility to maintain the system?
correct?
I don't think individually, no.
Okay. So if the people in the HOA wouldn't talk to her, and wouldn't say who put those in, especially when one's on her private property without an easement, what does that leave a private person to do if they're flooding?
I'm not going to give your client legal advice.
Well, I'd be interested to hear what you thought, though,
I'm not going to
because
answer
it may
that
be the same
question.
as what I think. So thank you, that's all I have.
Are you ready? Do you want to provide a case?
Oh, yes. I'm going to ask you your name. Can you give me, can you say your name out loud to all the noise? Okay, just want to make sure. Okay, if you'll speak into this, please. Will you state your name, ma'am?
My name is Diane Melody Goglas.
Okay. And Ms. Goglas, for simplicity's sake, you're the landowner, homeowner of Lot 7 that we've been talking about today, correct?
Yes, sir.
Okay. And you've talked to these people that have testified, at least most of them, prior to today?
Yes,
Okay. And you're the person that paid to have somebody, and out of your pocket, to put concrete in those manholes, correct?
yes.
Why?
Because it was broken and eroding my property. I had sinkholes. I had a man cutting my grass, and his leg went in through the hole. I begged for mercy. I begged county to help me. I also
You begged
went
who to help you?
the county.
Okay, and what did the county tell you?
It's private property that can't get involved.
And did you just beg one person or multiple people at multiple times?
From 2013 till today, not today, but prior to the situation, I asked multiple people, and I did a lot of research and a lot of microfiche, and still no one in the county office would not help me. And they had a turnover, and they have a new group.
That you were talking to, you mean?
Yes, and I went multiple times. I have the sticker to prove it.
Okay. And did you try and contact anybody from the homeowners association above you?
Yes, I contacted Tana Harris. She mocked me. She called me ghetto. She they also had a meeting, a board meeting, which I have the recording. She mentioned in the recording that, we don't need her property. Our drains are working. So I was not getting any cooperation from anybody. Then also, for 2 years, since 2021, that's when you gave me that letter from Barbara Stage that they have no easement, they have no rights to my property, and that that's it. And I was like left to handle everything.
Who's Barbara Stage?
That is the attorney to the Shadow Bay Club.
Okay, you got a letter, or I got a letter, an
Yes.
email letter, correct?
Yes, yes,
And said they have no rights to anything on your property?
yes.
Period. Okay. And you've had a little experience with this county, have you not?
Yes, I have.
You worked for this county?
Yes, I did.
In what position?
I'm deputy sheriff with Seminole County, and I've been there for 20 years.
Okay, you're retired now.
I am retired now.
Okay. And even with that prior job working with the county, nobody in the county would help you? And what were those two manholes doing to your property other than what you said?
A lot of the employees there know that I was experiencing flooding, sinkholes. I called the fire department, and they said this has been happening for 30 years. My realtor, Linda A. Miller, had sold me the house, and she gave me a clear title with construction only and no drainage. and then to find out that the catch drain runs directly under my house. Then after that, somebody came and spliced it in 2018, and
Spliced what?
spliced a abandoned, filled-in pipe, which they weren't supposed to touch. I saw a bag of rocks inside the pipe shoved in there. That's when I got a sinkhole. I also have a photo of that. And then I saw on Lot 8, she had a little manhole where the water was gushing from the back, which is the pond, all the way to the front, exiting upwards. And then all of a sudden, that water just took all my land away.
Okay, were any of those, either one of those manholes directly on your property?
The two manholes are there on my Lot 7, but it wasn't there when I purchased the house. And the reason why I know that is because in 2013, when we had floodings, and I do have pictures or videos showing floodings, and then I also have the pictures of the erosion and sinkhole.
When did those?
Wait a second, I don't think she answered your question.
I'm sorry. That's what was, she
What
said.
was unclear, Your Honor?
You said, you asked her if those two manholes were,
I said it was on my property.
you said, but they weren't on your property until.
Oh, that is correct, ma'am. You're correct. In 2012, I bought the house, and I did not have any manholes on my property.
When did you first see them?
I saw a manhole, a tiny one, on Lot 8.
When did you first see it?
That was in 2013, May. And
When did you first see them on your property?
Yeah, let's talk about your property.
2019.
So they just appeared one day?
No, actually, Tana Harris exposed them.
What do you mean by that?
She dug it up, but it wasn't there because I had a sinkhole in the same area, and there was nothing there. And there was a gentleman, I have to say gentleman, I don't want to, say the wrong thing, but he was in the manhole correcting, not the manhole, the sinkhole, correcting like the wires, the piping, because I had a sinkhole. And so he was putting dirt back in my ground. And then he goes, do you know that the storm drain runs underneath your house? I did not know. I wasn't a realtor back then. And then he told me that the drain runs underneath my house. I didn't know. I just went to work because I had to get to briefing. And then 2019.
Let's stop for a second.
Go ahead.
You were told that a manhole went under your house, and when was this?
The original pipe.
Not the manhole, the pipe.
Yeah, the original pipe that belonged to the condos, the configuration runs underneath my house.
Okay, you don't know that for sure, you read it in a report, correct?
Actually, yes, the engineer that Mark Rodriguez gave me, the documents, I have multiple documents here from Marco.
What?
And, hold on. Mark Rodriguez himself provided me a whole bunch of documents, how the floodings happened in 1991, and that they do not have any outlets. And that's why it's flooded in Montego Inlet all the way down to Shadow Bay Boulevard.
And who's Mark Rodriguez?
He is the president to the Shadow Bay Club Association. He provided me, he came into my house and provided me documents.
And what did the document show?
Like,
It showed about that pipe in there that they
Yeah.
found in what year?
hold on, let me pull that one up. It says here, as requested, I investigated the storm drain system for the Shadow Bay Club residential area. Upon visiting the site Saturday, February 13, 1993, I found that a new home was under construction. The south wall of this new home is constructed directly on top of the 20-foot-inch RCP outfall, which goes from the catch basin opposite Cactel Court to the northerly retention basin. This outfall carries all of the storm water from the Shadow Bay Club's storm drainage system. Documentation on file at Century Management shows a 20-foot wide easement, which we don't deny there's an easement, For the construction, which is my side, that's how I was clear title and sold this property, and the maintenance of the storm drain outfall, which Lot 8 is the storm drain. I have documents for that, too. The pipeline under the house, is not manufactured to carry the load of the house and will collapse. This will result in a blockage of your storm water runoff and flooding of Shadow Bay Club. This then would directly result in a shortened life of the road pavement. And this was dated February 23, 1993.
And when did you get that?
I got this in 2021 from Mark Rodriguez.
And this plastic pipe that was going to be run, they hadn't built your house, you weren't living in it, you didn't own it then, right?
No.
When did you buy it?
2012, which looked nice. I didn't see the storm drain. There was
Okay.
nothing there.
That
And
drain
then-
they were talking about was on your private property, not part of the easement, is that correct?
It's outside the easement.
Well, that's your private property, right?
That's correct.
It's not part of the easement.
Correct.
Do you know how that got there, other than what you read in that thing?
Are you referring to the pipe that's underneath my house?
Yes.
Okay, that was there from the condos when they were built. The county approved the pipe system back then. Okay, yes, you approved it. You did your job. It was correct. But they were forewarned to move it, and they didn't move it. They filled it
Who was
with
forewarned to move it?
the Shadow Bay Club.
And they didn't
Because
move
they
it?
didn't move it. So they filled it with concrete.
Okay, now the two...
No, they
ma-
didn't, no, they didn't fill it
Yes, they
with
did, because if
concrete.
you look into the hole, you can see that it's been chiseled, the concrete.
Okay, so I think Vladimir, he testified
He said-
that
yes.
it was severed and it was
No, it's connected.
filled.
It's all connected.
He said severed and filled under the house. What was under the house?
You don't know, you haven't seen the one under the house.
The general contractor did. That is somewhere in my house.
Can you provide me with the information that
Yes,
you
I
just?
will.
Oh, no, I'd like to know now. I don't want you to.
Yes, tell her, don't tell me.
Okay, can you put that map on, the map, on the one that had the green on it, that my general contractor was telling me? But I told him he was incorrect.
That's number 6.
Oh, your
Number
general,
6?
you let your general contractor know he was incorrect?
Yes, because I saw, and he corrected me, he told me.
What did he tell you?
Okay, let's wait till they get it up there.
Are you referencing under tab
The one you were
5,
saying
the
that it was,
survey that you gave to us at that meeting?
6, I think.
Your
it is.
you
survey?
said it was severed, when you were up there showing the pipe was
What are you
severed?
talking
Oh,
about?
okay.
It's this one here.
Yeah, that's what she's going to put
Yeah,
up.
it's number 6.
Are you going to put it up on the screen?
If I know which one it is.
It's 6.
It's not in there.
No, it's not in there.
Well, I think it was up there at one time, is all I
Yeah,
know.
it was up there because we put it on this system.
It's my 6. I'm sorry.
Yeah, it's 6. It's 5 in the book.
Oh, okay, I think it is. I'm looking at it the wrong
Page
direction.
2 of 5, yep.
I pulled the tab up, but that's for the next one, so it's 5. I'm sorry.
And it was where Vladimir had testified that it had been severed and
Yeah.
brought over into the easement.
The manhole, which is a 4-foot circumference, 6 foot deep.
We're talking about the one under your house.
Yes.
It was severed from the pipe under your house.
Yeah. Can I go up
Okay.
there and show you?
Yeah, I mean, can you give me some background on your qualifications?
I saw it.
Are you an engineer?
No, the general contractor showed me it was underneath my house.
Okay, so you're not an engineer, but you want to show me,
Where it was.
you just want to show me?
Just to give you an idea.
Okay. Over here on the actual paper, if you'll,
So this catch drain, can you see it? Mm-hmm. Okay, so this catch drain, am I everybody can say, this catch drain, this culvert cement piping goes straight underneath my house like that. It's not severed. They put the manhole in between that, and it's a straight line.
Who
This
is they?
I don't know who put it
But it
there.
just appeared in your yard one day
Yes.
while you were at work?
No, my neighbor took me on a camping trip. Linda Miller and Sherry Fatula, the ones that sold me my house, took me on a camping trip, and I have it on my calendar. And someone else in the office, about two of them, and also a gentleman by the name of Doug Fox, who was the original owner, and I have him on camera. He said, do you know that Robert Miller and Linda Miller had opened up their ground and extended it to my ground? So at that time, I have it on the date of the video. I have to look at the phone. But that's when the change were made, in 2018. So here...
So stop for a second. You came back from a camping trip and there was a manhole in your front yard.
No, you don't see it because it was nicely plush with grass and everything. Everything was room.
So when did you first see it?
The only reason when I first saw it was when Tana Harris opened it up.
Who's Tanner Harris?
She's here in the audience. She left? Okay. She was the president of the HOA at the time.
Okay, so
I know, ma'am, Your Honor, it is such a cluster, and now the whole community wants to put the blame on me, and I've been having washouts, and I can show you the videos
okay,
I have.
let's stick to what.
One thing
okay,
at a time.
So you were telling me that a pipe went under the ground. Did you hear the testimony of the engineer?
Yes,
Okay. And
That's
so you're
incorrect.
disputing the testimony of the engineer?
that's correct.
Okay.
Because the manhole's in the middle of the original pipe.
Okay. And then what are you saying the manhole goes to?
To that original pipe, so here, this pipe has been tampered
Is the
with.
original pipe, and
Yeah,
there's...
that was tampered with. When I first saw it, I saw a bag of rocks inside. Okay, there was nothing here. So then, later on in years, from 2013, after having all the, caved-in sinkholes, then this here, my neighbor was cutting my grass and his leg went through a hole. And then shortly after, that's when Tana Harris came over, and then she lifted the earth or the grass from those two areas. That's all I can describe because that's what I saw.
Okay, so then the original pipe, then you've described for me exactly what Vladimir described.
That is correct. It is, but over here it looks off, but it's not. It's actually going underneath my house.
But the pipe, the original pipe in the grate from the street is not connected to your house anymore.
It's underneath my house, but
No, the pipe's still there.
The pipe is still there, and the manhole is there.
Right.
Yes.
But then the pipe...
And it's outside the easement.
Well, it always was. And the pipe is now diverted into the easement and then goes down the easement into a new
On
pipe.
Lot 8.
Well, it's in between both lots, is what it looks like.
Well, it's supposed, on the survey of Lot 8, it's supposed to be 10 foot of that, 5 foot of that 10 foot.
Okay, but do you understand, regardless of whether all of it is on Lot 8, in the Lot 8 easement, that it is connecting from the road from your property?
Yeah, but the thing is, I don't understand your question. You'll have to repeat from the road. But it wasn't there. Nothing was there, so I was having sinkholes.
What do you mean nothing was there?
Because when we're talking about sinkhole, huge like this. It was really big. And then I had another sinkhole. Again, you don't see it. It's been changed.
Yeah, I realize that. They diverted the pipe into the easement.
Who?
I don't have any clue, but the testimony shows that they've diverted the pipe into the easement.
Sit down. Yeah, so who diverted the pipe?
I thought you were going to...
Okay, I'll go. I went to Vladimir, and I said, Vladimir, who permitted this contraption on my property?
I'm not concerned with that, and that's not what I'm asking.
Okay, what is your question?
Are you aware, and I believe you are because it's what you stated, that that pipe that used to go under your house has been diverted into the easement area, which you say is all on Lot 8, and it runs down to the pond?
The pipe?
That doesn't make any sense.
Okay, yeah, because there's a little confusion.
Oh, wait a second, were you testifying? Because I wasn't asking you the question, sir, I was asking her.
Okay,
And I don't appreciate that you just gave her testimony right in front of me.
I said it didn't make any sense, ma'am.
okay, now,
So were you directing her that it didn't make any sense?
Actually, I'd like to question her rather than you.
No, because this is my proceeding.
That's correct.
Okay, so I'll
I'd
finish and then you can finish.
just like to clarify, that's all.
okay, catch drain is the checkered square box there on the property.
In the
that
road.
belongs shadow.
In the road,
That is correct.
yes.
No, that's not in the road. That's it's next to a tree in the medium,
Okay.
okay?
Do you have to cross a concrete or a asphalt
There's a
road?
sidewalk
to get to it?
between that square box and
Okay.
then that property line.
Okay, so it's in the right of way.
Correct.
Okay,
So that line is crooked. It goes straight to and under my house. It is
excuse
correct.
me, ma'am, if you're going to testify from the audience, I'm going to ask you to leave.
So, when I bought the house, I had sinkholes. I have it on my...
Ma'am, you
But I'm
are,
ready to tell you.
you are diverting all over the place. Let's
That's
stick
right,
with the
because
line.
there's so much multiple things.
Let's stick with the line that you were talking
Okay.
about that's under your house.
That's the culvert cement drainage that's outside of the easement.
Okay, and it's always been there.
Right.
Okay. So then at some point in time, we're not sure when, you came home from a camping trip. Maybe there was a camping trip involved, I don't really know.
Doesn't matter.
But at some point,
Right, at some point.
the pipe was, it stayed the pipe that was always there, and then it got, from that point, diverted into the easement as it's shown on your survey. Is that correct?
Okay, that's not correct survey. My survey is on page on here. That's an investigative survey for Barbara Stage and for my lawyer. That's what we were looking for, the truth. That is not the correct survey. When I bought the house...
Wait. Who provided this survey?
We were investigating.
Okay, so
We had a general contractor to see, in fact, why I'm having sinkholes.
Okay, I did not ask you about your sinkholes, okay?
Oh, okay.
You can get to providing that testimony about your sinkholes in a moment.
Okay.
I need us to stop diverting all over the place. Let's
All right.
stick with the subject that we're talking about.
All right.
This survey that we're looking at, you provided to the county. I don't care whether you did
I
it for
didn't
investigation.
provide that to the county.
Is this
That was
survey the
provided by
one-
Shadow Bay Club, and that was only strictly private between the lawyers. And then later on, after 2 years passed, they
Okay.
provided this new system.
Stop for a moment. Was this provided by the property owner?
When we were in it, we had this before we met with the property owner.
Okay.
And when we met with the property owner, she provided it then too, when we were going over it.
Okay.
No, I didn't.
Now, I'm asking a very specific question here. Who had this survey prepared?
It should be on the bottom there.
But who commissioned the survey? Not who prepared it. Who commissioned the survey?
No, actually, the general contractor ordered it because I was going to do construction.
Did you pay for it, ma'am?
Yes, through the...
Okay. So this survey that you paid for, that we're looking at right now, it shows that the pipe comes down your property and then is diverted into the easement, whether it's on Lot 7 or Lot 8, it's diverted into the easements that touch one another.
It was not there when I purchased the house.
It may
was-
not have been. It may not have been, but it is right now. Is that correct? This survey correct?
it's there right now.
Okay, okay.
But it was broken.
Which part was broken?
Well, they should know.
No, I'm asking you.
Sorry. One of their workers told me that it was broken in 2 places. So I don't know if I should go further with this
Well,
information.
where is it broken? Can you identify on the diagram where it's broken?
One of their contractors that came out, I said,
Whose contractor?
I have it on my phone.
Whose contractor? You said there.
Shadow Bay Club.
Okay, okay,
They had multiple contractors come out.
okay,
I was able to talk to 2 of them.
okay.
They both said the same thing, but I happened to get 1 contact. Oh, no, 2 contacts.
Okay.
But right here right here and right here was broken. That's what I was told.
Okay, you didn't see it.
Actually, I know that they told me they took video cameras or whatever.
Okay, did you see a broken pipe?
I only know it because
Did you see a broken pipe?
I have a photo of the water in there, but as far as I understand, but the thing is,
Ma'am, I asked you if you saw with your eyes
does it
a broken pipe.
okay, does a man's leg, a whole leg go into the ground considered a broken pipe? I don't know how to answer that question because I've been having sinkholes, and they know that there was sinkholes. I
Ma'am.
have pictures.
If I show you this piece of paper, and it's this
I
whole piece of
understand that.
paper,
I
but
understand
now
that.
it's ripped. Do you see the rip?
I understand that.
Okay, so did
I
you
was
see a
told-
pipe?
I was told,
So you didn't see it?
no.
Okay. But you sort of identified 2 places that you said
was
you were
told
told
to
it was
me.
broken.
Yes.
Okay, and when was this,
When was it?
that you were told this?
I would have to look at the phone for the actual exact date. I
Was
have-
it,
2019, 20, whenever they came out, the Shadow Bay Club came out to do the investigation.
so it was broken for 3 years approximately, 4 years before you filled in the pipes with the concrete?
Well, I've been having sinkholes, okay, from this period to this period, so I've been having problems. And then from this period, 2018 and 2019, that's when we had a problem. And then continuous problem till 2004, which they still did not address if they were going to help the situation.
Okay, I don't
When
know who
went-
they is, but,
The Shadow Bay Club.
okay. Did you ever hire an engineer to come out to your property and assess your drainage on your property?
Yes, I did.
And who was the engineer that you hired?
I didn't hire him. He came to investigate it.
Okay, so you never hired him.
I still have him on back, on communication.
But
No,
did
I
you-
did not hire him because I was trying to find out who's responsible for this.
But you said you were experiencing problems on your property. Did you hire an engineer to tell you to fill the pipes?
After I exhausted all avenues,
Did you hire an engineer who told you to fill the pipes?
I don't know if he's an engineer or not, but he filled in the pipes. If you're talking about a drainage engineer, I don't know what you're referring to.
Yes, I'm talking about, did you hire a drainage engineer to assess what was going on your property, and that person told you to fill in the
No.
pipes?
No, this person
Okay.
came in to fill in the pipes because it was broken.
Because you asked them to?
That is correct.
Okay, thank you. I have nothing further.
Okay, thank you. So,
basically, she has to, all of it is on her property. And I bought the house with construction only.
No, you can't say that.
I know.
We have nothing further, Your Honor.
Okay, so any of the items that you have discussed having as evidence, did you want to submit any of those items into the record?
Did we use anything other than theirs?
I only have, what kind of items in reference to filling in the storm drain that you want? I mean, I am telling you that I've had problems and sinkholes. I have those pictures if that's what you want.
I want you to provide me with what you believe is evidence to support your
My-
case that you're not in violation of the county code that you have been cited for. Do you have any printed out items that I can?
I can't because it's an old iPad, and this was dated in 2013.
And what is it that you're,
It shows how there's a bag of rocks shoved into something. And then it shows that this is not the same, it's not connected to anything, and there's a bag of rocks. But nothing is connected to my property. And there was a neighbor that told me that, oh, the neighbor did that for their own purpose.
you have something that shows that this pipe is not connected to the overall drainage system?
I just have a photo that's not the same.
Did you want to show that to the county attorney?
That's not the same. That's, what is this? That's on lot 8, and that's what I told you, it was like a light bulb, you know, the shape of a light bulb, but it's not connected to anything. There's another bag of rocks, it's not connected to anything. Okay, do you want to see anything else?
Unless,
Because-
only if you're gonna
see?
submit it.
I would have to figure out a way how to print this. You see the bag of rocks? It opened up. Do you need to see it, ma'am?
Well, if you're going to submit it into evidence, but I don't know how you're going to do that. If you didn't,
I would have to get a I-Tech person to help me with it.
you didn't come prepared to submit anything into evidence.
Well, actually, if I'm not mistaken, maybe you don't have it. I can check to see if I can email pictures to you. If you give me an email, I can submit it that way to evidence.
Okay.
I can do it sitting down now. But do
Okay.
you want me to show it on the screen?
Yeah, we'll need each one of the photos that you're going to email and submit into evidence. We'll need to have you put them on the screen and explain what they are.
Okay. All right, that is on lot 8. It looks big there, but it's not that size, it's really small. And that,
Okay, but you have no identifying, okay, is there a date at the top of that?
yeah,
Okay.
June 14, 2013, at 8:46 a.m.
And you're indicating that that's on Lot 8, which is not your property?
That's correct.
Okay, and
it's, I don't see any connection, but I should have another picture. Hold on.
but what do you mean you don't see a connection?
You said connecting to another manhole or something like that?
No.
Oh, here's another.
I'm going to object to these pictures. They're not relevant if they're on Lot 8. We're only talking about the manholes that were filled on Lot 7. But, I mean, is this the manhole that's under the fence now, that's filled with cement?
This has since moved to my side of the property.
So I'm going to object to the relevance of these photographs.
But it's
Okay.
not the same.
Okay, is this a photo you want to submit into evidence?
Can I talk to my client for a minute?
Absolutely.
We don't own her property. That's
just no. That's really the problems.
Can't you say that you go down there and saw those pipes broken?
Let me see. I can show this.
No, can you say what I asked you?
I just know I was told that I was broken. They showed me these pictures.
Okay.
Listen.
Yeah, that'll do any good.
I have to spend all this time to the tongue.
Well. I'll forget. Your Honor, we're not going to offer that. I have two other questions, though, before we're done here.
Okay.
You said that you got a deed to your house that did not show there was an easement on it when you bought it?
When I bought the house, I got a deed and this,
Does it say there's an easement on it?
I'm not sure how to answer. No, but
Just say yes or
no.
no. Okay. Did the persons that had the house before you, did they show an easement on their deed? You do have copies of them, don't you?
Yes,
Do they show an easement?
no.
Did you have any reason to believe when you bought the house there was an easement on it?
Can you pull your microphone down, please? I'm sorry.
I'm sorry.
No,
In the back of your house, Lot 7, is there any drain?
no,
As long as you've lived there, have you ever seen water drain out of the back of your house anywhere?
no,
Is there a drain on Lot 8?
yes,
Okay. And it's pretty visible. You might have showed that to Vladimir, did you?
he never came out to the property,
Not with you, when you were there.
no.
And you tried to communicate with the homeowners association about those two drains before you had them concreted?
Because.
Yes or no, please?
No.
Was there a reason why you didn't?
A correction. Repeat the question?
Did you ever try and communicate with anyone from the homeowners association about those new drains that you ended up concreting?
Yes, I have. It was more like a battle because, can I reiterate something? I have a document here that because a tri-party agreement, and it's not my fault, that the HOA from several years ago, maybe 30, relinquished their responsibility to an HOA. And so Shadow Bay Club relinquished themselves from the responsibility to whatever, I don't know. But that's when I was like concerned, who's responsible for this? Why is it on my property? It wasn't there before. Who's going to maintain it? Vladimir told me I was. And I don't know. I don't know how I'm duped with something that wasn't there before, and now I'm responsible to fix, repair something that wasn't there.
Okay, and one of those drains was partially on your private property,
Yes,
and that's the one that went to that, to your knowledge, went to the pipe under your house?
yes. So
Okay.
2 times out of the easement.
And was there, the pipe between that drain and that pipe under the house, was that broken?
Yes,
How do you know that?
because I had an engineer, and he came out to verify, yes, it's broken. They had like maybe 3 engineers, and one of them, 2 of them told me that it was broken in 2 places.
So to your knowledge, there was no drainage out of that one manhole that was partially on your private property? There was no drainage anywhere?
No, the water was just sitting there, it wasn't flowing.
Okay. And no one from the condominium association would act responsible for anything, or what?
It's actually the townhomes, and no, because we're not HOA and you're on your own. Those are the comments I got. And since there's no HOA, I have that document that says that, and I also have a video, audio, I can put it on the mic if you want, of
No,
what they said.
Just testify, please.
Okay, repeat the question, please? I'm sorry, there's so much involved in this case.
Well, let me ask another question. The other manhole that you concreted that was on the easement, did it go to property 8? Did it have any pipes out of it to property 8?
I saw a hole going towards that way.
But was it open?
It was open, yes.
Okay. Was the manhole always flooded?
It was always full of water from the back of the pond to the front. That was always full of water. The only reason why I
Now, what are you
know,
talking about? What,
okay, from the back of the pond
on Lot 8?
on Lot 8, the water goes in. Because you know the plastic you saw? The moment the plastic came out off, the water went in. So that pipe is not full. They're saying that I'm filled that whole pipe on Lot 8, and I did not, ma'am. That's open. And if you put whatever engineer equipment in there, you're going to find that it's open. Okay? And then the catch drain to the manhole, that's open. And it's actually still trespassing on my property. But
So
the
you
only thing
filled
I did,
in between them?
I'm sorry?
You filled in between them?
Yeah, because that was the broken area, and I was having sinkholes. The guy's leg went in the ground. I put the yellow tape to help prevent other people to come on my property to get hurt. I did everything possible, and all they did was laugh at me. You know, I just couldn't get cooperation and help from them, and, you know.
Who's them?
The Shadow Bay Club, my community, the one that I protected and served as a deputy sheriff, that I couldn't get back help. I could not get help back because Tana Harris, she saw it, she assessed it, they wouldn't communicate with him, they would not help him, they laughed at him, they ignored his paperwork, so their attorney, Barbara Sage, sent a letter to him saying, I'm sorry, we don't have any jurisdiction, we don't have an easement through your property. And that letter, we have it, and we can present it to you for record. And so then all of a sudden, from there, 2 years later, I'm here to be humiliated.
Okay, that's all I have, and I'd like to offer that letter into evidence, Your Honor. It's an email.
Okay.
And then, you know, okay, I don't think I need to speak.
Okay, I have two
Where's the letter?
questions.
Where's the letter?
When you closed on your property, did you have title insurance?
Yes,
And
and
you-
that, go ahead, ma'am.
You went to a title company to,
Just answer the question.
Yes,
okay, and you had title work done then, because you had title
Yes.
insurance? Okay. And you saw the pictures earlier of the flooding in the street. How, and you've lived there since 2012, how many times have you seen that?
every
prior?
summer.
Okay,
Yes, every summer.
okay.
When
You-
there's a storm.
Okay,
Just
so-
like Swenson told me that those drains that they have,
No, I asked you if you saw, what you saw.
I have it on a video. I saw the
Oh,
same.
you do have a video of it?
Yeah,
Okay,
I saw the same thing you saw.
but prior to 2024?
13 is when all this started.
So
May 13 and June, and June also.
So every year from 2013,
I've been having.
no, not you, the
Okay.
road.
The road, every year, yes, that's flooded.
So every year since 2013, you've seen the road flooded like that?
Yes, ma'am.
But no one's ever complained before?
No.
Now?
A lot of these are a lot of new residents now.
So every year there's new residents?
No. Like Robin and Mark Rodriguez are new. They're about 3 years young. I've been here for 12 years. Most of the homeowners know that it's been flooding. I do have what Mark Rodriguez gave me, that's been flooding from They have a problem with, I can show it to you and put it on exhibit.
Okay, you have evidence where it's flooded each year
Yes.
in the road, not your property, the road.
I have a video from 2013 twice, May and June.
Of the road.
Yeah, and then I
Okay.
have 2021, 2020, 2020.
And you have those with you to where you could email them?
Yes.
Okay, I'd certainly like you to show them if you have
Oh, yeah,
evidence
show 'em.
of the road flooding.
Can you-
Not your property, the road.
Yes, can you guide me with the questions there so I can show it to you?
Yeah.
In case I missed something.
I'd like you to show the county attorney what you're going to show, though.
Is it?
Mr. Bush, show me first.
Oh, okay,
Please.
ma'am. I just put it on Facebook. And I'll show you the metadata. Let me go back to my Facebook.
You're going to have to submit it into the electronic record. You'll have
This
to
is
provide it to the
March
county.
30th, 2021.
Yeah, she's not doing any of those pictures, so the pictures are off the table. I'm not sure whether this is going to materialize into anything or not.
Okay. That's the mailbox.
That's your mailbox there. Okay.
And you see my driveway and the street is, again, going that way in front of that house across the street from the
Right.
house.
Okay.
And then, again, oops. Oh, shoot. Oh, sorry.
Are they videos or pictures?
Photos.
I
Okay.
have videos on the iPad. Again, here.
I mean, photos are better, actually, if you just have some still photos. I think that'll be easier to keep in the record.
Okay, and I can-
Can you explain where this is taken?
This is in front of my house. So
this
that's Lot 8's mailbox.
Okay. Okay.
And then, okay, the same thing, Lot 8's mailbox, and now you can see it on my property. And it's next to the electrical box, because they had me come out at 10 o'clock at night to remove my fence to get to the electrical box. That was the same movement. Yeah. Yeah, see? And you can see the mulch, how far it went up.
Yeah.
Okay? I'm just being honest.
All right, are those the only ones you're going to show?
Oh, I need to show you
Yeah.
first?
Mhm, that's the procedure.
Thank you, that's all right. I'm glad you're inviting me. Okay.
I think those are just of the
I know, no.
manhole from before. Maybe that there.
Let's see here. You can see the
That
mulch
doesn't
here.
look any.
The mulch is
Oh,
up here.
this is,
Oops.
what's the date on this one?
June 18, 2000.
2023? Okay.
Oh, no, 13. 2000.
2013.
Yeah. You need more? So that's.
I think that's it, right? Or do you have?
Yeah, I have more.
No, it's up to you, how much more you want to put in.
I have more. 2020, 20, 21, and 22. Okay. Photos. That. What year is this one?
Did you take all these photographs yourself?
Yes, ma'am.
Okay.
Let me find the year 22. No, that's Hearts, hold on. 22. Okay.
I need you to go ahead and decide which ones you're going to show. It was incumbent upon you to bring those with you to the hearing, so.
to an IT, you know.
No, but they need to be here, and so
I can
I'm
email it if you give me the.
I'm going to give you some leeway to do that, but I need you to decide which ones you're going to do.
20.
No, you haven't found them yet, and I'm not going to wait
No, I
much
showed her
longer.
2020, 2021. I'm looking for 2022, 2013.
And she has showed you each of those photos?
Yes.
Okay. Okay, you need
And
to
she's
just,
verified that she's taken them, and we don't have an objection if she
Okay.
wants to show those.
I need you to decide which ones you're going to show, and I need you to show them. And then you'll need to email the ones that you show.
Show here?
Yes.
Okay. Thank you. That's March 30th, 2021 at 4:54 PM.
Okay, wait, go back to it. I need you to show it better on the screen. I need you to tell me what I'm looking at.
Okay, you're looking at the streets and it's flooded. Thank you. You're looking at the street and it's flooded. And there you go. All right, so that's that one. I do have the metadata for it. It's just that consensus.
But go back to that for a second.
This one?
Yeah. So
That's my mailbox.
what is your mailbox?
This,
Okay. Okay.
that's my mailbox here. This is the medium and this is the street.
Okay.
You see where my trash is right there?
Yeah, and I see those cars. Okay.
Yeah,
I
so
can
it's the
see
same.
cars.
Now, I'm going to another year, which is August 9, 2020, and you can see the front of my house, how it's flooded in that area here. You see the sidewalks? And then the neighbor's Lot 8 mailbox is right there. So, and then you can see it, how it's going up by the electrical box over there.
In your property?
Yes.
Okay.
Electrical box over there, and it's past a cable. Okay, and then my driveway, and you can see down the street. And to the left, so you see the water on the left here. Let me see if I can move that up. Okay. You see all that, that's covering the sidewalk, the water's covering sidewalk. And you can see here, I'm sorry, you can see here where the mulch is, how high it went up here.
Okay. So each one of those photos, you're going to email?
I'm going to email you.
Only the photos
2020.
you showed?
I could look for 2022.
No.
Okay.
I mean, unless you have them right now.
I have to look for it,
Okay.
because there's so many, but I
Okay,
do
but I
have
gave you the
2,000.
time to do that. If you haven't found them yet,
That's okay, it's still the same difference.
okay.
Okay, and then here,
You have to move it up a little bit. Oh, okay, you're not ready.
let's see. Can you see it? You can see the mulch on the neighbor's property
You can see the water level where all the
and
mulch
the
is,
dirt.
right by the control car vehicle up to the bricks.
You want me to stop?
You know, it's just, I think it's stopped up.
Okay. What else do you want me to?
No, it's you. It's not
Oh,
them.
well, I showed her pictures, so I didn't know, I didn't want to violate
it's-
what
no,
I
it's-
showed her.
I've seen both of those.
Yeah, so
Okay.
it's
They're
what
fine.
you want to submit. So
Okay.
you're only showing the things you want to submit.
All right, let me see if I
That
have
you've shown
more.
her.
Wait, water. stop
Here
it.
we have a drainage problem.
I did not see this one.
So you want me to continue it? Let's stop it.
Well, you can show us both, and if she objects, she'll object and provide. If not, she will.
It has been reported for about a month ago, almost 30 days. This is how the street slowly flooded. Goes up to 3 houses. So across the street, which is not passing too much, but when it gets really full of water, the whole entire street is full. And one of the houses, the water goes straight up to the garage. I hope that this problem gets resolved as soon as possible before a disaster hits. I'm really concerned with my properties.
Okay, so do you have an objection to that video being submitted? Is that a video you want submitted?
What was the date on the video? I missed that because I did not see it.
That is June 6, 2013 at 8:51 a.m.
Okay, I have no objection.
Okay, so the two videos that you showed and the photos that you showed,
Can you give me a pen, please?
are you asking to submit those into evidence?
Yes.
Okay, then you will need to email those to the clerk.
Okay, I can do that. What I will have to do with this video, I'm going to have to use my phone to video the date with that video. Because unless you know how I can forward it from my iPad, or I talk to an iTech person.
I was under the impression that you had
I can find out.
the
but-
capability to do that right away, but, okay, well, if the county has no objection,
No objection.
okay,
Okay,
we'll
so-
accept it.
We're going to be sending in June 6, 2013, 8:51 a.m., correct? And then, let's see which one's this one, and with the patrol car, right? Which is June 18, 2013,
That was the video, that was the
Six-
video? The
6:37.
first video you showed?
Yeah, it was, we had June 6, 2013, 8:51 a.m. And then we had, I have a couple of them, but June 18, 2013, 6:37 p.m.
Okay, those were, you only showed two.
Yeah,
Okay. So were those the two you showed?
yes,
Okay, so then those are the two you're going to email?
yes.
You have those dates so you can verify that those are the ones she's submitting?
Let me see.
Okay.
Yes.
And then the photos that you submitted from
You
2021?
can see the water level where the
Sorry. Go ahead.
The photos from your phone from 2021?
2021, 2022, 2020.
No.
No,
don't
you
want
only showed
2022?
21 that I was aware of.
I showed her 2020 and 2021.
Okay, then the ones you showed her and the ones you showed on the overhead
I
are
can
the only
forward that.
ones you provide?
Yes, I can provide that.
Okay, okay.
I can look for the 2022 if you have
I-
time.
Well, we're
No.
already an hour and a half into.
That's fine.
And we have multiple hearings
It's the
after
same
yours.
thing, it looks the same.
Okay,
Yeah,
I'll accept your testimony to that fact.
yeah. Thank you, ma'am. Anything else?
You tell me. Do you have anything further?
You wanted to see the pictures? Okay.
And you wanted to submit the letter,
That's what she's looking for.
the letter from the Homeowners Association attorney.
Yes.
Have you seen the letter?
I had not seen a letter, I've seen an email.
Is it,
It's an
email
email
via
letter.
I probably have seen it.
okay, do you have an objection to it being submitted into evidence?
No.
No, get the one thing.
I'm going to. Is this it? Let me see.
Isn't it?
No, it's probably all together.
I thought you read from it a few minutes ago. Give me part of the stack.
I have here, am I speak? Okay, this here. Authorization of council to void the agreement. Okay.
I mean, if it's the same letter, they can forward it by, yes, I have received the email. I mean, I don't have it on me in my file, but it's in my email files. If you could forward it to the clerk with the rest of the information, we can move on. Although I
Yes,
will
that's it.
say that it's,
We have it.
okay.
Put it up on the screen.
If I could read it. Thank you. Here, let me give you this. No, I'm going to accept it into evidence. You don't have one?
I have a copy. That's
Okay.
yours, but I have one. I just didn't bring it with me. We're about done.
Okay, I'll accept the email into the record as evidence presented by the respondent.
Can I just take a quick look at it? We can keep moving. I'll just read through it real quick.
Okay. Do you have anything further?
You have anything further? No. Tell me, not her. No, I don't want to go there.
Okay, so then whatever else.
That's all we have, Your Honor.
Okay.
Yes, I have some redirect questions for Mr.
Okay.
for the property owner.
Okay.
Ms. Googlis, I just want you to verify that this is your warranty deed. I had it in my file.
Okay, that's correct, but this is not correct. It's because we have no HOA, and this wasn't presented to me,
It says it on your deed.
but it wasn't presented to me.
Doesn't make any difference. She's asking if that's what your
Okay,
deed says.
yes, this is my deed.
Okay, do you have any objection to me entering into the record?
Nope.
Nope.
She's entering it in because it's got something about easements.
Okay.
Okay, the warranty deed will be accepted into the record as evidence presented by the county.
Ms. Guglas, when you purchased your property, what was the legal description contained in your deed for your property?
Lot 7, Lake Vista at Shadow Bay, according to the plat thereof, as recorded in Plat Book 45, page 81, Public Records of Seminole County, Florida.
Thank you. And does your deed state that the conveyance to you via warranty deed is subject to any easements of record?
It says it on my deed, subject to covenants, restriction, easements of record, and taxes for the current year, which I never seen on, I never was provided any of that information.
Okay, thank you. In the pictures that you showed here, to your recollection, when you were taking those photos of the flooding, the ones you just entered into the record, and the 2 videos, do you know what type of storm event was occurring at that time?
I just have the dates, I don't know.
Okay, so you don't know if it
It's
was
just heavy.
tropical storm related or hurricane related or just a regular rainstorm?
It could be heavy rain. If it stays on the streets, then it could be just a heavy rain season or storm.
And for the pictures that you took, we saw 2 video clips that were roughly, I don't know, between 15 and 30 seconds each. For the pictures that you showed, were those pictures all taken at the same time on the same day?
I gave you the pictures from 2000.
I just want to know if, and let me make myself more clear.
They're not the same, the 2020 and 2021.
I understand that, but those 2 groups of pictures, when you took them, were they all taken at the same time? So say it was
Yes,
5
yes.
o'clock in the afternoon,
Yes,
you
maybe
went 5 o'clock, 5 o'clock, 5 o'clock.
Yes, maybe a minute apart.
Okay, yes, that's all I needed to know.
Yes.
I have no further questions.
Thank you.
Anything further?
Nothing further.
Okay. So, after hearing all of the evidence and, or testimony and considering the evidence that has been presented, I find that Seminole County Code Section 270.412 defines an interconnected stormwater system. And I find that the testimony of the development review manager, who was also an engineer, indicates that the system from the drain, the pipes that run onto the respondent's property that have been now diverted into the easement and run straight back into the easement, whether it's on Lot 7 or Lot 8, and dump into the stormwater pond, are all part of the same system. I'm going to find that the actual reading of a document by the respondent from an engineer indicated that the pipe that was under her home was not constructed to withstand the weight of her home, and so the system was diverted into the pipes that are in the easement. And I'm going to find that the photos that were taken by Mary Robinson on September 9th show vast flooding different from any other types of flooding that I've seen, that would also evidence that the system, once filled with concrete, that system is interconnected, and that's the result. I'm going to find that the property owner herself testified to filling in the concrete in between, in the center area of the outfall pipe that goes into the storm pond and the drainage grate in the front of the pipe system. And because what was filled in those manholes located on her property or not, they are all part of that system. And that is a violation of Seminole County Section 270.414, because it otherwise caused damage to the pipes and the drainage system, or the drainage structure, which are all part of that system. I'm going to find that the rain is only going to get worse. And so the violation needs to be corrected by October 1st. And how that is corrected is up to the property owner, but the pipes need to be unplugged so that that system flows properly. And if the violation is not corrected by October 1st, there will be a fine imposed of $250 a day. Thank you.
Can I say something?
Sure.
Okay, if that gets corrected, how does it flow?
I think you need to hire a drainage engineer to correct the system.
But isn't there somebody that's supposed to maintain it?
I don't know how you're going to do it, but I know that there is evidence that you purchased this home.
To fix it?
You purchased this home with this drainage system on your
No.
property.
No, I did not.
Oh, okay. The evidence that has been presented to me today shows that you purchased this home with the drainage system encumbering your property. And so because of that, what you have done, you have impeded the drainage system. And if it is not corrected by October 1st, the impediment that you created, a fine in the amount of $250 a day will go against your property. Now, there will be a compliance hearing at our next meeting in October, which is October 10th. So the compliance hearing will be for any evidence and testimony related to whether the violation has been corrected. At that time, if evidence is presented that the violation has not been corrected, at that time is when the fine would be imposed, and it would be imposed retroactively back to October 1st if the violation has not been corrected.
So to correct it, I have till now, until when?
October 1st.
You know, I wish you would be more respectful. This is a serious matter. Yeah, it sure is. And you guys didn't care when I was in the dying mercy need.
Okay, enough.
October 1st, ma'am?
Yes.
2024. Okay. And then October 10th, 2024 is when we reconvene.
Yes. If you're in compliance, and the county tells you that you're in compliance, and you just need to verify with the county officials, I believe, Mary, are you her contact? Okay.
Do I need to have an engineer from the county, or do I have to get a permit for doing this?
Ms. Skoglas, we can help you with the permit. We can help you shepherd you through the permit process and give you that information. The special magistrate doesn't have that information.
Because there wasn't a permit when I was looking for it.
Okay, so the county can help you with all of that, and as long as, if you're in compliance, then you don't have to come back here on October 9th, or October 10th.
Okay.
If you're in compliance, you're done. Thank you.
She means by
Thank you.
corrected.
I'm sorry?
I don't know what she means by corrected.
I don't know what she means by corrected either, because it wasn't functioning.
Okay, we're going to take a 5-minute break.
Lowry, yeah.
Hey, we're going to call back to your order. And I'm going to go ahead and call Mr. Love. We'll do all of your cases. First, we'll do 2367 CESM.
Thank you.
Did you give him all three of his? Okay.
Yes, that's right. While we're getting set up for the record, McGregor Love, 215 North Eola Drive, the Lowndes Law Firm. Thank you.
Okay, I'm ready when you're ready. You've been sworn already.
Have I? No.
You did not get sworn when
No.
we swore, okay.
No, sorry.
Okay, any other county employees who need to be sworn? If you haven't been sworn, raise your right hand. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Jason Rucker, Seminole County Inspector. This is case number 2367 CESM. Ifran Lima and Kelly Enduris, 3125 Lowry Drive, Oviedo. The violation was Seminole County Code Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by Special Magistrate on November 16th, 2023, and an order was issued giving the respondents a compliance date of July 10th, 2024, with a scheduled meeting of July 11th, 2024. An order was issued on July 11th, 2024, extending the compliance date to August 7th, 2024, with a meeting scheduled for August 8th, 2024. An affidavit of noncompliance was filed by the inspector after re-inspecting on August 6th, 2024. On August 8th, 2024, an order was issued extending the compliance date to September 11th, 2024, with a meeting scheduled for September 12th, 2024, with a stipulation of submitting a site plan on or before September 11th, 2024. The finding of facts and conclusion of law, order, imposed fines dated November 16th, 2023 shall be imposed being on July 11th, 2024 if the site plan is not submitted. Administrative costs processed this case for the inspector totals $913.35. The administrative costs to process this case for the clerk totals $193.10. That's a total for the inspector and the clerk of $1,106.45. Recommend that special magistrate issue an order constituting a lien in the amount of $3,200 for 64 days of noncompliance from July 11th, 2024 through and including September 12th, 2024 at $50 a day, and a fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after September 12th, 2024.
So was the site plan submitted?
To my knowledge, there was a partial site plan that was they tried to submit, but
Megan, do you want to address that?
Good afternoon, Megan Zanorski, Project Coordinator for the record. CID, our Central Intake Desk, received application for site plan earlier this afternoon. It was forwarded to the planning manager and myself and Sarah Hartung, our Natural Resource Officer, for a cursory review before the application was taken in for completeness. It did not meet cursory review for several deficiencies. It did not show all of the structures that are outstanding on the property, did not show the normal high water line. It did not show the amount of fill on the property. There were several issues with the site plan in and of itself that was submitted. It just was not complete as far as what we're looking for and what has been outlined to the property owners as what was going to be required to be a site plan for the amount of fill. There was not an arbor permit submitted. There's been trees removed. It just was not a complete application for what needed to be submitted for a site plan. And
Okay.
and it was submitted today.
So, okay. In other applications, do you do a cursory review, or do you just accept them in?
We will do a cursory review, especially when we've had meetings with customers prior, or they're doing a resubmittal, or for code enforcement, will this meet your needs? Does this have everything on it before I finalize the survey, or is this what you need? We will do that before we take in an application.
Okay, so did we accept partial and give them comments, or did we give it back to them?
I will let Dale speak to the status of that.
Okay.
Dale Hall, Planning and Development Manager. We received Alexis B., who is the clerk, received an email from Mr. Love today at 11 o'clock that basically said that, and I have it here, I can give it to everyone. Can you let me know whether this is what I'll read it. Can you just let me know whether this is a site plan? I may hang back a bit and, we'll hang. Also for the record, I'll just read that one. So it was submitted to the clerk, which is not our process for site plan review.
Electronically?
Alexis B., right.
Electronically or?
Electronically. An
Okay.
email was sent
Okay.
with a site plan, what was potentially a site plan, and wanted her to comment on. We typically don't take things through that process. There was no application. We have a full application process that has been expressed and told to the applicant multiple times on how to submit. So as a courtesy, we immediately sent it to some of our plan reviews to see how complete it was. And with the time available, we were only available to come up with some things, but in a quick glance, we have a list of items that show that this application did not meet, or this submittal didn't meet a site plan. So we have that available for everyone right now. The applicant has not received this because we did not have adequate time to do a thorough review, and we don't give partial reviews. We do an entire review. What we would have done in this case, if it was any other applicant, we would have just sent it back to them and said, do a complete application and send it through the proper processes. Okay. We do partial reviews on occasion, but we've done multiple partial reviews on certain things, and we only have so much time to spend on items. So I have things for the record if you would like them. If not, I'd be more than happy to answer any more additional questions that may come up.
If you have something you want to submit, that's fine, but
Sure.
I
I will submit. Well, we don't have it's a partial plan review.
So then just submitting your,
right.
okay, just
We'll hold
submitting
that
your
up.
testimony is
Right.
fine.
My testimony's fine.
Okay. Mr.
Now,
Pike.
I do want to add
sorry,
one thing.
sure.
There was a correspondence. Mr. Love had sent a survey to Megan on August 13th, in which he mentioned in his email, this is outside your purview, but wanted to send this along. And then he asked for a meeting with the county staff to go over what's needed for submittal on the site plan, at which time he said he would like to measure twice and cut once, if possible. And I sent an email back to him 2 days later, which basically said, yeah, this is outside staff's purview to do this, and we've met multiple times. This is what the site plan entails. Give him a copy of the letter that was sent from staff on December 1st, 2023, that outlined what a site plan submittal is and what's required on a site plan, and then said the Development Review Committee would love to schedule a meeting to discuss the site plan after the application has been submitted. Okay. This I would like to submit for the public record.
Okay. Do you have a copy for Mr. Love?
Absolutely. This stuff's going to fall on the floor if I don't give it to you. All right. Clerk, Magistrate.
Thank you.
Okay.
So I could provide some context here.
Okay, well,
Yeah.
one more second, because I think the county's not done yet, so as soon as.
Sure thing.
Okay.
For the record, Bob Pike, Building Official, Seminole County. I just want to state for the record that Planning and Zoning has reached out and sent them multiple letters on the exact items that need to be included in a site plan. And I know that they have met with them at least 3 or 4 times, and Building Department has met with them at least 3 or 4 times. So it was all been made clear, very clear, what was needed at these meetings with everybody involved. And here we are today, and we still don't have what is needed. So I just wanted to make that record get that said for the record, and that's all I have. Thank you.
Okay, thank you. Is there anything further from the county?
That concludes the presentation.
Okay, would you like to submit the electronic case file into the record,
Yes, I would.
along with the email that Mr. Hall provided? Do you have any objection?
I have an objection to the email because
Okay.
it was misstated.
Okay.
Would you like me to read the email that I sent, Your Honor?
So the email that he just handed you is not what he provided to you?
Oh, no, I apologize, the email he handed me is correct. The email he read into the record is incorrect.
Okay, do you have an objection to
No,
the email
no,
he provided?
no.
Okay, then I'll accept the electronic case file and the email provided by Mr. Hall into the record. Okay.
So I'll start with the email that I sent earlier today because it is genuinely a misunderstanding about why I was sending that to Alexis. So I stated, Alexis, I was chatting with Sarah Hartung, who's here today, Environmental Department, and she mentioned that Shadow Bay may be the first up and take a while. Could you please let me know whether that is the plan? I may hang back for a bit and let the crowd disperse. Also, for your records, I wanted to show you the attached in connection with 3125 Lowry Drive. And the reason I sent it to Alexis is so that you could have it as part of your record, not to submit it formally as a site plan application to the clerk of the Code Enforcement Department, but rather to send it so that it was part of your record.
Okay, and so that's what these documents are
Correct.
that Alexis provided me? Okay, okay.
So, and in terms of the discussion that I've had with staff regarding the plans,
Wait one second. So staff has seen these 2 documents that were provided to Alexis, is that correct? Okay, I'm sorry, go ahead.
So what I'm learning today is that, not all of staff have seen it for as long as it's been circulated, because mostly I've been working with Jim Potter, the county engineer, to figure out what is needed for this small site plan. And code is helpful in directing you to kind of what's required here, but because of the nature of the changes that were made to the property without permits, and the changes that were made since they originally did some survey work, like we have a wetland delineation line from 2017 that's no longer really trustworthy because Phil has been brought in the interim, and so we need to have a new wetland delineation performed. All this was information that was not necessarily clear from code or from the correspondence that I reviewed, but Jim was excellent at walking me through all of it. So was Sarah in the environmental department. So what you have before you, and I'm not sure, are you looking, Your Honor, at one plan, or are you looking at, are there two individual documents that you have?
Two individual documents.
Okay. So the one that has a zoning sign-off on it from Paula Archer, that is the site plan from 2016 that shows a wetland delineation line there at the northwest. That is the line that Sarah has informed me needs to be kind of remeasured based on the changes that have occurred in the intervening years. And the property owner has asked their their surveyor to perform that work. The other plan that you have is the plan that I have been working on with, mostly with Jim Potter, that includes the information that, in his opinion, would be necessary to process the small site plan. And Jim was very clear with me that it's a multi-department review and that he can't guarantee me that other departments won't want to see other items on the plan. But Jim was looking to make this as, as practical and easy to work through as possible for my client. And we're trying to work towards providing all the information that the county actually needs to process this. So that's the background with the site plan. I didn't want to give you the impression that I tried to submit it several hours before this hearing. We've been working on it for a little bit, trying to figure out what's needed on that plan. But we don't allege that we have met your the terms of your order. We believe that we can submit a sufficient plan very soon. But what we need is the information from an arbor specialist about what trees were removed, the species, the caliper size, all that information needs to be reflected on this site plan. We also need a new wetland delineation line, which we'll have added. Those are the two items that I'm aware that we need, but we will work with all the departments to figure out if there are other items. And it sounds like there was a quick review performed today, so perhaps more comments came from that.
Okay. So is that all?
Yes, Your Honor.
Okay, I'll accept the two documents into the record just as the documents that you referenced during your statements. Is there any objection by the county to these documents? Okay. I have to tell you, I'm very disappointed because I feel like we've been working on this for a very long time, and I've heard about the wetland issue for many months, so I'm having a hard time believing that it was just discovered in the last 30 days.
No, I don't allege that it was discovered in the last 30 days, no.
And I know you didn't allege that, but again, this goes to the deficiency and the knowledge of what is going on the property by your clients and their continued failure to just hire someone to get the things done that they need to get done. And so I've reached the point where I'm going to go ahead and I'm going to impose the fine, and I'm not going to provide another continuance. And I'm going to impose it retroactive back to July 11th because the site plan was supposed to be submitted yesterday, and it wasn't submitted. And so my recommendation is that the sooner that they get this all taken care of and get all staff's desires on their site plan, not just engineering, because engineering has different things that they look at than planning and zoning and so forth. that they get a site plan that everyone can bless so that these building permits can get issued. That's where we're headed. And the sooner they get that done, the sooner the fine stops. So our real issue is the fact that we don't have building permits for these structures. And I understand that a site plan is the preliminary for that, but that's what our real goal is getting building permits for these structures. So I am going to go ahead and impose the fine effective July 11th, 2024. It's $50 a day. It will continue each and every day until such time as the violation is corrected. And soon as it is, that is certainly something, I mean, fine reductions are something that I'm sure happen all the time from the county. If, you know, you file the proper paperwork to get that taken care of, then I'm sure that they will process it accordingly. But I just urge you to get this in and get it done so that we can get the permits for the property.
Understood.
I'm also going to impose administrative costs in the amount of $1,106.45. How long would you like for them to pay that?
Honestly, what is typical for your orders?
Typically 30 days, but I'll give you longer if they're trying to come up with fees for these other applications that they're submitting,
I'll ask for 60, if that's okay.
Okay. And those need to be paid within 60 days of the order. If they're not paid, there'll be a lien that goes along with the other fines that have been imposed. Okay?
Understood.
All right, thank you.
Thank you.
We're going to go ahead and call the next case, which is 2417 CESM, Efrain Lima and Kelly Andres. I'll remind you, you're under oath.
Yes. Jason Rucker, Seminole County Inspector. This is case number 2417 CESM, Efrain Lima and Kelly Andres, 3125 Lowry Drive in Oviedo. Violation charge Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by Special Magistrate on March 14th, 2024, and an order was issued giving the respondents a compliance date of April 10th, 2024. On April 11th, 2024, an order was issued extending the compliance date to July 10th, 2024, with a meeting of July 11th, 2024. On July 11th, 2024, an order was issued extending the compliance date to August 7th, 2024, with the stipulation of providing a building official access to the property no later than July 12th, 2024, to verify the electrical revisions. In the event the building official is not permitted to access the property in order, the continuance granted pursuant to the second amended order will be revoked, and the penalty set forth of finding of fact, conclusion of law, order imposing fines of March 14, 2024 shall be imposed beginning on July 11, 2024. An affidavit of noncompliance was filed by the inspector after reinspection on August 6, 2024. On August 8, 2024, an order was issued extending the compliance date to September 11, 2024, with a meeting scheduled for September 12, 2024, with a stipulation of submitting the site plan on before September 11, 2024. The findings of fact and conclusion of law and order impose fines dated November 16, 2023, shall be imposed being on July 11, 2024, if site plan is not submitted. The administrative cost in this case for the inspector was $685.72. The administrative cost for the clerk totals $150.90, with a total cost of $836.62. Recommendation is that the special magistrate issue an order constituting a lien in the amount of $16,000 for 64 days of noncompliance from July 11th, 2024 through and including September 12th, 2024 at $250 a day, and a fine shall continue to accrue at $250 per day for each day the violation continues or is repeated after September 12th, 2024. That concludes my presentation, and I request that this be submitted to the clerk.
Okay. Do you have any objection to the electronic case file being submitted?
No objection.
Okay.
The factual background for this one is identical to the last one. I would ask for your consideration of continuing this violation date, given that it's $250 a day, and it would avoid the necessity of having to reduce two fines, and this one would become very significant very quickly, especially given the road that we have ahead of us. But of course, it is certainly within your discretion to make whatever order you deem fit, but I would ask for that relief.
Okay. What I'm going to do is I'm going to order the fine to go into effect today. So the accrued fines of $16,000, I'll just make the fine effective today. Or actually yesterday, because yesterday was the compliance date. So it'll be effective yesterday. $250 a day starting yesterday, moving forward. And I will also impose costs in the amount of $836.62 to be paid within 60 days.
Thank you.
Okay. All right, and the next case, 2425, CESM, Ahmed and Sakina Nur Muhammad.
Jason Rucker, Seminole County Building. This is case number 2425 CESM. Hamid and Sakina Nur Hamad at 846 Isle Point, Sanford, Florida. Violation charge is Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by Special Magistrate on April 11, 2024, and an order was issued giving the respondent a compliance date of July 10, 2024, with a meeting scheduled of July 11, 2024. An affidavit of noncompliance was filed by the inspector after reinspection on July 10, 2024. On July 11, 2024, an order was issued extending the compliance date to September 11, 2024, with a meeting scheduled for September 12, 2024. The administrative cost to process this for the clerk totals $1,045.11. The administrative cost to process the case for the inspector totals $447.22. The total cost for both the inspector and the clerk was $592.33. We recommend the special magistrate issue an order constituting a lien in the amount of $50 for 1 day of noncompliance from September 11, 2024 through and including September 12, 2024 at $50 per day, and the fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after September 12, 2024. That concludes my presentation, and I would like to request that this be entered into record.
Is there any objection to the electronic case file being admitted into the record?
Your Honor, I didn't see it in his presentation, but in the electronic case file I have here on page 6, it provides that no permits have been issued to correct the violations. There is an open building permit for this.
It's in, excuse me, I'm sorry. Go ahead.
No, if you have clarification.
That's in plan check, so it has not been issued. So they're still checking.
Okay, understood.
So it has to be issued before the violation can be closed.
Understood. Other than that, no objection to the, I think that the term, I believe it's been issued, but it hasn't been approved. Because we've received, I believe building and several departments have actually submitted their comments and no objection to the plans.
It's in plan check, ma'am. Megan Zanorsky for the record. Sarah Hartung and I both have comments on this permit that are outstanding because the retaining wall encroaches into a conservation easement that neither the HOA nor Seminole County will approve. The retaining wall needs to be relocated outside the conservation easement.
So I can speak to that issue, unless the county has something else on the permit.
Okay.
So that is what we've been trying to sort out is whether the county has the authority to approve improvements within a drainage and conservation easement, because the land development code suggests that it does. And I was just speaking with Rebecca Hammock about this, and she assured me she's going to look into it, and I have been discussing it with Sarah Hartung as well. And I'll read you the code section here that I believe is at issue. It refers to any portion of and this is section, let's see, I apologize, I don't have the specific code section in this snip that I took of it, but it says any portion of the platted lot which lies below the 100-year floodplain or elevation or wetlands line must be dedicated to the public as a drainage easement, a conservation easement, or both. No filling or grade level change will be permitted which will adversely affect any surrounding area. So there is a qualifying, there is an affirmative demonstration that's required to improve within a conservation and drainage easement, but it is not a blanket prohibition. And it's further complicated by the HOA's internal documents. One document says, well, we cannot allow you to improve within the conservation and drainage easement, and please see our, unattached lake and canal regulations, which I obtained a copy of, and those specifically provide, I'll read you this language, and this is from a letter that I sent to the HOA. No docks, retaining walls are permitted within the conservation and drainage easements without pre-approval from Seminole County government and the Architectural Review Committee. So we're in this sort of catch-22 where the Architectural Review Committee is telling us, well, we can't, the Seminole County won't let you do that, and Seminole County is of the belief currently that they don't have the authority to do it. I don't think that anyone is trying to stymie us, but I think we need to sort out whether there is a path. And if the answer is it must be removed, it must be moved back, then that's what my client's prepared to do. But I don't think we've gotten to that answer yet.
Okay, so Megan, let me ask you this. When was the last communication that you've had related to this?
We've had no resubmittals on this permit since the original submittal.
Okay. So who have you been communicating with, Sarah?
Yes, Sarah.
Okay, and
Sarah and I have been communicating regularly about her communications.
okay, and so how often have those occurred? Have they been regular that you've?
I know it's been off and on. I don't know that it's been very consistent, but I know he's also dealing with the HOA because it is, from my understanding, if I remember the plat correctly, that it's like dual designated to both the HOA and Seminole County. And we also have it's not just the code section, but we also have our definitions of conservation easement, and that it's supposed to be open, natural, and basically no construction. It's supposed to be left in its natural state. So I'll leave it to Rebecca. If Rebecca's researching it, I'll leave it to our director. That's under her purview to do so, and she may come to an understanding or an interpretation of the code that I don't have. But that's the conversations that I've had with the HOA board members and previous conversations with the director, that it was not in our purview to approve.
And the other confusing issue about this particular easement, it's just dedicated on a plat. There's no separate easement document. And what it provides is this is a drainage and conservation easement, but then when it describes what the purpose of the easement is, because this is a man-made lake, this is not a natural water body, it says it's for maintenance and drainage purposes. So the conservation element of it almost seems like superfluous language, almost like just standard thrown in there. I think that I would like my client to have the opportunity to show that it will not adversely affect neighboring property owners. I mean, the reason he did this in the first place is because the first hurricane flooded his property. His engineer is very confident that they did this in a responsible way. I'd like for there to be an audience to make that showing. If there's not, then there's no intention to finish it against the county's code, but I think we need to get to the answer.
Okay, and so Megan, you're telling me that Sarah is working on this?
Correct. She's been in communication with Mr. Lowe.
Okay, so I don't feel comfortable imposing the fine if we are in fact working on this issue and we haven't made a final decision. Once there's a final decision, obviously, it either, if the final decision is that it needs to go,
I
it
mean, if
needs
he's
to
been in
go.
communication with Rebecca, I don't have anything to go on other than that he's communicated with Rebecca directly. If you want to do another continuance for 30 days, and I would assume that within 30 days she would have her determination, we can revisit it.
Okay, so I think that probably sounds reasonable.
Absolutely.
So that means let's keep in constant communication so that we're not back here in 30 days and we still don't have an answer. Let's, on both sides, let's make sure we do that.
Absolutely.
Okay, so I'll go ahead and continue the compliance date to October 9th is the day before our next meeting. Okay.
Thank you, Your Honor.
Thank you. Okay, and then the case, which, which case was that? If she needed the interpreter case.
Oh, that's Ruby Court. No?
Which,
That's one expense fee, right?
Ruby,
Is it All-Stars?
Ruby Court is one of them.
okay, Ruby Court, is 2445 here? CESM? Okay,
Westlake.
then what was that other one?
Westlake.
Westlake.
I don't see her. Where did the lady, oh, right there, the lady that asked for the interpreter? What's your name?
Amy,
Oh, this is a different lady.
she's here to be the interpreter.
For, okay, so,
One of the respondents. They had told us that we needed to have an interpreter.
yeah, so are we letting this young lady go? Okay. And so this lady right back here that's shaking her head, who? Okay, 2359 CESM.
Miss Morales. Yeah. Westlake Brantley, correct?
Yeah, All-Star Assisted Living. Yeah. Yes, please. And so I need to swear you in first. Do you solemnly swear to translate from English to Spanish and Spanish to English to the best of your ability?
Yes.
Okay, now we're going to swear her in. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
¿Usted jura que va a decir toda la verdad y solamente la verdad? Sí. She does.
Okay, thank you. Go ahead.
Jason Rucker, Seminole County Inspector. This is case number 2359 CESM, All Stars Assisted Living Incorporated, Alicia Morales, at 1131 West Lake Brantley Road, Altamont Springs. Violation charge is the Seminole County Code, Chapter 40, Appendix A, Section 105.1. Construction without the required permit. On September 14, 2023, Special Magistrate issued an order giving the respondent a compliance date of December 15, 2023, and scheduling a compliance hearing for January 11, 2024. An affidavit of noncompliance was filed by the inspector after reinspection on December 15, 2023. On January 11, 2024, the special magistrate issued an amended order extending the respondents to a compliance date of February 7, 2024, with a meeting on February 8, 2024. On February 8, 2024, Special Magistrate issued a second amended order extending the respondent's compliance date of June 12, 2024, with a meeting scheduled for June 13, 2024. On June 13, 2024, Special Magistrate issued a third amended order extending the respondent's compliance date of August 21st, 2024, with a meeting scheduled for September 12, 2024. An affidavit of noncompliance was filed by the inspector on August 22nd, 2024, after reinspection. The administrative cost to process this case for the inspector totals $767.02. The administrative cost to process this case for the clerk was $286.38. For a total for the inspector and clerk was $1,053.40. Recommendation, recommend the special magistrate issues an order constituting a lien in the amount of $1,150 for 23 days of noncompliance from August 21st, 2024 through and including September 12th, 2024 at $50 per day, and a fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after September 12th, 2024. That concludes my presentation and request that this be submitted into record.
Okay. He's requesting that the electronic case file be submitted into the record that she has in front of her. Does she have an objection?
Quieren saber que si pueden someter esto electrónicamente para que se pueda mantener en los récords. Si usted tiene ¿está de acuerdo que lo pueden someter o no?
Can you speak into the microphone? I need her to speak into the microphone.
¿Puede hablar, por favor?
Okay. I try to do my English and you can help me when I need it, okay? So I know that I was supposed to come back in August, but I never receive the invitation. So I missed that one. So because you gave us the time to make a decision what to do. And you said we even can have extra time if we need it.
Okay, before we go into that, I need to know if you have an objection to the electronic case file. That is what you're looking at right now. They're asking to submit it into the record.
Sí, entendido esa parte y lo único que quieren es saber si pueden someter todas esas fotos electrónicamente. So, sí. She says yes.
Okay, then I'll accept the electronic case file into the record. Okay, now does she want to present information regarding the case? The county has indicated that you are not in compliance still.
Yeah. I guess that I explained better.
Sí, me lo puedo decir a mí.
Okay. Nosotros comenzamos con este proceso.
They started this process
several months, algunos meses atrás. Tratamos de seguir las indicaciones que se dieron aquí.
They tried to follow the requirements from the county.
Y que sometiéramos un permiso.
To submit for a permit.
Contratamos al ingeniero, contratamos primero el constructor, después y se
They
hicieron
hired a
los
contractor,
planos.
they made the plans.
Allí salieron no somos, que somos condado, pero que a la misma vez no seguimos las distancias que tiene el condado, que si fuera city, fuera diferente.
So, que no siguieron ustedes,
No.
siguieron lo de la ciudad en vez del
Ok.
condado.
Yo compré esta propiedad
Ajá.
ya con una construcción sin permiso.
So she said she bought the property with the alteration, la adición.
Es una construcción.
Oh, so she brought the property with the construction already there.
No, she's already testified to that plenty of
Okay.
times. So,
Okay.
Dijo que ya había testificado usted de eso.
Ok, sí. Entonces, el detalle es que la última vez que o sea, que nosotros quisimos hacer lo que aquí se nos pidió, de sacar el permiso, se sometieron los planos, se dijo que no cumple con los zoning.
Okay, so she said last time when they submitted the plans that I guess the comments that she received that the setbacks did not meet the requirements
Del zoning.
from zoning.
Ok, y nos dieron dos opciones.
They gave her two options.
Y de esas opciones nos dieron que si necesitábamos más tiempo, que nos podían dar más tiempo.
They said the first one was to give her an extended period of time.
Ok, pero yo no recibí la invitación a ese hearing.
She said that she didn't get the second letter the letter from August to come and be present for the hearing.
Yeah.
she was present at the hearing.
No, de August no.
Oh, I believe she's confused. We didn't come to a hearing in August. Her compliance date in the last order, which was my third amended order, indicated that she needed to come into compliance by August 21st, 2024, and she didn't do that according to the officer.
Okay, so ella dijo que lo que no era que tenía que presentarse usted aquí necesariamente, sino que tenía que hacerse como confirmar que usted ya había trabajado
Okay,
y había llegado a solucionar todo esto.
Ok, lo que yo entendí es que veníamos aquí y que tenía que decir una final decisión de lo que se iba a hacer, pero como yo nunca recibí el 23 de agosto, yo traté de comunicarme con Vicky, pero Vicky no estaba contestando al teléfono, llamé como 3 veces.
Okay, so she said she's been trying to communicate with Vicky. She thought that she had to be present here for the August 23rd, but I explained to her that that was not the hearing, that was the...
August 23rd isn't even a date. That is...
No, I know that was in August, so I don't have that date specific, but I was waiting for the invitation.
Pero no era una invitación, solamente era que usted tiene que demostrar que ya había solucionado todo este problema.
Sí, pero como me dijeron que podía tener tiempo extendido, yo estaba esperando venir aquí a que me dieran el tiempo extendido.
Pero eso, ¿quién se lo dijo?
Ella.
She's under the impression, I'm sorry, Judge, that you had given her, that she had to come here in August to get an, extended time to come in compliance. That was her misunderstanding.
Okay, and has there been any communication whatsoever?
The only communication is when I posted the property. I talked to her the last time I was there for this hearing.
Okay.
To make sure that they got the notice to be here.
Okay.
But other than that, no. I mean, to my knowledge, I mean, it's still the same. They're trying to put an accessory dwelling, make a shed into an accessory dwelling
Yeah, but
on
one
the
of the
back
options.
that doesn't meet the requirements.
Okay, do you want to let her know that?
One of the options that was offered was to do the variance, and that's what I want to pursue.
Okay, but the variance can only be for a shed, for storage, unless you come in and redo your special exception.
¿Sí entendió eso? Okay, ¿sí lo entendió? Que eso solamente para un shed que se puede hacer, solamente si viene aquí y lo hace por una... what was it, the special?
Special exception.
Una especial excepción.
Sí, eso
Okay, es lo que quiere hacer. I guess she wants to do the special exception.
Okay, so this was where I explained to you upstairs that you might have to reconfigure the property and it might have to be attached because you're not allowed detached living quarters.
Dice, si entendí esa parte, dijo que va a tener que entonces decir que la estructura esté pegada a la casa para que cambien los códigos para que se pueda aplicar eso.
Sí.
Porque ahora mismo no está pegada a la propiedad. Okay.
But to answer your question, ma'am, the only communication I've had is a resubmittal from the contractor that is literally just resubmitting the same documentation over and over again with no response to comments. They're not changing any of the plans. They're not changing anything. They're not even responding back. There's boxes that they can type in, response to comments, asking questions. There's zero communication, no communication by phone, by email with the contractor. It's zero.
Yeah,
Okay.
basically, I'm doing it this. He is not really involved anymore. He is not really doing anything because we are waiting.
But the plans don't meet what have to exist inside the shed. It has to be a shed, and it's not a shed.
Okay, to be a shed, what need to be done?
We can talk about that upstairs because it needs to be storage only. We've had this discussion. I've laid it out. I provide you your special exception documents. We can outline it for you again and make it very clear for you. And you'll need to talk to a planner about your special exception process and what will be and won't be allowed.
Or that is something that I need to do by myself, or I need to get involved with another contractor?
A contractor will not be able to do it. You could hire a consultant to do it for you. Again, if you'd like to come upstairs on the second floor when we're open, we'll be happy to help you with that.
Okay.
And when were the discussions?
Months ago. They came maybe 3 months ago upstairs, her and her husband. I provided them with a special exception. I went over the documentation, the fact that the variance didn't go through the first time with the shed when the original people put it up. I don't know that the shed's even had its final inspection for the second story addition that was added onto it. There's a ton of issues with the original structure of the shed in and of itself alone, let alone the conversions that were made to it. So I'm trying to help her the best that I can in explaining the complex nature of this structure that exists and trying to get her where she wants to be. But it is complex. She's going to need a variance if the variance can be approved. She's going to have to redo her special exception to add on to it because those are all things that have to go through public hearing process.
And the problem that I'm having with it is today I'm hearing the same testimony that I heard when I originally heard this case, that this was here when you bought the property. And that is a problem for me because they have tried to communicate with you and you've not listened to what they've asked you to do. And so each time that you have been in front of me, you've said you wanted to do something different. And you overtly made changes to a structure that did not have permits.
No, I didn't make any changes. The only thing I did, I replaced a rug for another rug, a carpet for another carpet. I didn't make those changes.
You didn't put the stairs on the outside?
No.
So you bought the property with it like that?
I reinforced what was there.
You bought what was, it had all of that on it?
Completely. Everything is the same was.
Okay.
I just replaced toilet for another toilet. Replaced a carpet for another carpet. I didn't create new things.
Okay. But nonetheless, they have been trying to explain to you what you need to do.
Yeah, but when I came here, you asked me to submit the permit. I have the whole hope that I spent $15,000 in engineering, in the plans, and everything was revoked. And I'm just trying to save what I can take from those $15,000. What use can I have for this building that benefits $15,000? Is a lot of money for me.
But you put $15,000 into the building?
No, in the engineering and in the plans.
For the building, and then found out that the building cannot be where it is?
Correct. I just follow, if from the beginning you can tell me this is not going to happen, I don't spend that money.
Okay. And did we, when this originally came before me in September of 2023, at that time, had she been notified that she couldn't, she was going to need all of these other things with her, with the zoning?
We probably wouldn't have known that right off the bat until she had submitted something. So once she submitted, then we would follow the permitting process with going to zoning to figure all that out. Because we don't know on the initial violation when we're out there whether she meets or not. So-
Because of the survey and things that are
Correct.
submitted with the application show where it's located and whether it violates the setbacks
Correct.
and those sorts of things. So that's another struggle that I'm having because she purchased without, she purchased with it like this and hasn't made any changes. Now, do you all have the ability to know when these changes were made or when it?
We can try to do aerial photographs, but
It's hard to
sometimes it doesn't-
say.
Yeah, sometimes it doesn't say, and that doesn't necessarily, that would give us the outside, and that doesn't necessarily give us what was done interior.
Is anyone living in the structure?
No.
What's it being used for right now?
Storage. I created for me to live because I purchased this facility and my family stay in Tampa. In order for me to take care the residents that I take care, I need to have a place for my own. So I was inside in the same area. I said, okay, this is perfect for me. So I never thought I was incurring all these problems. I'm trying to do the best I can with all the money that we invest in the business, all the money that I need to create to build my facility and better standard to do a better life for these residents that was poor. And actually, that is something that probably the county need to be looking to places. When it's new, I encounter all the problems, but when it was there, nobody see the problems that was there. So I'm trying to do the best in my ability and my knowledge, which I don't have a lot of knowledge on these things. But right now, nobody's living in there. I have my things there. I used to live downstairs because sometimes I don't have staff at nighttime. I'm downstairs, but I have my personal items upstairs.
But wait, you're living in the downstairs portion of it?
No, downstairs means in the facility.
Oh, okay.
With my residents.
Okay.
Yeah.
Megan, how long would it take her to go through any of the processes that are necessary?
A variance, our cutoff is Friday. Minimum for that is it's 90 days because we don't have a hearing in November. And then the special exception, that's based on public hearing dates for community meetings, and then how that falls with P&Z and then BCC. So 6 months, easy. And that's based on how quickly she can get her drawings and her survey and all of the things done for the addition that she wants to do for the special exception, because none of that's done.
I have the survey that originally got from the.
But you're gonna have to have a site plan drawn with the addition placed on it. If you're adding on for a living space for you that's attached to the existing structure, because the structure that exists, that shed, cannot be converted to living space.
Okay.
Under any circumstances?
Under any circumstances, because of the commercial use on a residentially zoned lot, it cannot be detached living space.
Okay. So you cannot live in this structure unless it's attached to the other house?
Unfortunately, I understand and I agree.
Okay.
But what can I use this space that is useful my investment? Can I use it as an office? Can I use it as a?
When you come in, we will have to evaluate that with your special exception. You are not a typical residentially zoned lot. You have a commercial use on your property. And everything that you do that is outside a typical shed will affect your special exception.
Like I do anything to be legal, to be in peace?
Right, so what I'm asking you to do is to come in and visit this with a planner, so they have time to look at your special exception documents and what you'll need to do to be compliant, because I can't answer that because I don't have your special exception document in front of me.
So what we're trying to achieve here, though, is compliance with the building permit.
That, without anything extra, that needs to be converted back to a shed. And a variance obtained for the setbacks, because it does not meet the setback requirements for this zoning district.
Okay, so it has to either be demolished.
Correct.
Which would require a permit.
Correct.
Or you need to go through a process, either of which to get a variance for the setbacks.
Okay.
The variance process is going to take you 90 days. So there's no way she can come into compliance.
Before the first of the year.
Before the first of the year anyway.
Correct.
So we would be setting her up for failure by telling her, regardless, and then she bought this property in this way.
Correct.
So I'm inclined to continue you one more time for 90 days, which would be the first of the year, that next meeting. But I also am struggling because I'm afraid if I give you 90 days, that nothing's going to be done in the 90 days again.
No, ma'am. No.
But up until this point, I sat talking to you, and I was under the impression you understood exactly what we were talking about, and you said that you were going to comply the last time, and you didn't do anything.
Well, this is what happened. We feel like we had no other choice to destroy that. But I say, I need to see what can I benefit from that investment. I'm gonna try what else can do. I'm trying my last resource.
And I understand that, but your investment, individual.
My investment, when I means that, when I purchased the place.
No, I know what you
was
mean.
including that. But on top of that, what I spent with the engineering and the plans, that was a totally waste.
I know what you're saying, but your individual investment decisions have no bearing on the county's rules and regulations.
I follow what is being said to me here. That's what I did.
Yes, but you could have also, your engineer could have assessed it and looked at the code and saw that it didn't meet the setbacks. And so you didn't receive full advice either. So that's not the county's problem, that you went to a professional that didn't provide you with the proper advice. Because someone should be, if they're providing that information for you, they should be looking at the county's code to make sure that it's in compliance with the county's code as well. So what I'm going to do is, in application.
I want to clarify. So the cutoff for the next hearing date is tomorrow at 3:30. The application has to be submitted and paid for by 3:30 p.m. tomorrow.
Well, there's no way she could do that.
Nope, it's absolutely doable. We have the site plan already.
Okay.
Because it's attached to the permit.
Okay.
So as long as she completes the application and submits it and pays for it, we have applicants do it all the time. Within 24 hours, they find out they need a variance. We have it done all the time.
Okay.
It's not a complex application by any means. So if she can come in tomorrow, the girls at the counter can help her get it completed, and she can pay for it while she's here. We have notaries on staff and everything.
Then I'm going to just continue this for 30 days. And if you have not submitted your application and chosen a path, whatever that path is going to be, if you're going to demolish the structure, if you're going to invest more money in it and get a variance and use it for storage, whichever path you're going to take, you have 30 days to have chosen that path so that we can get you closer toward getting building permits issued for this structure. So I will revisit it in 30 days. I'll continue it. And I promise you, if you have not at least taken a step for a path and submitted an application, and they're telling you that tomorrow is the deadline for the next process for the variance, that I'm going to impose a fine. Okay? All right. I'll continue for 30 days. Thank you.
Por 30 días.
Which actually is by October 9th. I'll continue to October 9th.
Hasta octubre 9.
It's
And-
less than 30 days.
Yes, it's probably a little less than 30 days. Then October 10th is the next hearing here.
Will she have to be present for
Yes.
for October 10th?
Yes.
Usted va a tener que estar presente octubre 10, okay?
Thank you.
Okay, I'm going to call 22-103 Thomas Courtright. You had memorized your number, hadn't you? Yeah.
What's the case number? Where's that at?
You raise your right hand. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
This is my last one? All right.
Yeah, that's what I'm looking for, what page? There we go. Jason Rucker, Seminole County Inspector. This is case number 22-103 CESM. Thomas J. Cartwright Jr. At 5675 Deer Path Lane, Sanford, Florida. Violation charged is Seminole County Code, Chapter 40, Appendix A, 105.1, construction without the required permit. This case was originally heard by the Special Magistrate on December 8th, 2022, and an order was issued giving the respondent compliance date of March 9th, 2023.
Okay, Jason, I'm going to stop you right there.
Okay.
Because we know we amended several
Yeah,
times.
okay. You want me to get down to the costs?
With the last compliance date was entered on June 13th.
June 13th, 2024, the special magistrate issued an order extending the compliance date to August 21st, 2024, with the meeting on September 12th, 2024. An affidavit of noncompliance was filed after reinspection on June 12th, 2024. The administrative...
But wait, we're in compliance now, right? When was the compliance date?
Last Monday.
So the compliance date was... 8/21 was the compliance date.
Oh, so it was on the August 21st date? Okay. Okay.
Okay. So he is now in compliance. The administrative cost for the inspector on this totals $1,210.45. The administrative cost for the clerk on this case totals $338.70, totaling an administrative cost for both the inspector and the clerk of $1,549.15. Recommend that the special magistrate issue an order constituting a lien in the amount of no?
Nope, you're not doing that because he's
No,
in
ma'am.
compliance. No, he was in compliance as of the date of my order. So
I'm reading off the agenda.
talk to
sorry.
me a little bit. Remind me, did you purchase this property like this?
Yes, ma'am. Well, purchased the house that way. We did some of the renovations and, yeah, when the inspector came out the first time, we got fined for and cited for a lot of structures and dwellings that were built pre my purchasing the property, which everything now is in compliant finally after 22 permits, it feels like, and thousands upon thousands of dollars.
So I'm just kind of asking if there's anything we can do with some of these fines.
Okay, so you did make some of the changes without the permits, and
Yes,
you
ma'am.
acknowledge that? Okay. 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 So were you in compliance on August 21st or September 4th?
September 4th.
Okay. And what was the original per day fine amount?
$50 per day, wasn't it?
Okay, so you do have, this is accurate,
Yeah.
$750. Okay, so what I'm going to do is I'm going to, because compliance was achieved 15 days after the date of my order, I'm going to order that a fine in the amount of $750 is imposed against the property. And it will constitute a lien until you pay it off. And then I'm going to split the baby on costs. The costs are $1,549. I'm going to order $775 in costs to be paid within 60 days, or they will constitute a lien as well against the property. So the $775 is costs to be paid within 60 days, and the $750 amount is the fine stemming from the out of compliance for the 15 days. And it would just be recorded as a lien unless you pay both, then they'll go away.
So if they're both done within 30 days, there's no lien? Or it starts a lien now?
Well, the lien would be recorded as soon as my order is entered, but as soon as you pay it, it's gone.
Okay.
Okay?
Thank y'all.
Thank you.
Special Magistrate Andrew Lanius, County Attorney's Office. Can I make a quick announcement to your audience here? The Animal Services Board meeting is actually scheduled in here at 6. That has preemptively been moved because I think you guys might be going a little bit past 6. Is anybody here for the Animal Services Board meeting? Okay. Well, thank you, Magistrate. For anybody who happens to come in when I leave, the Animal Services Board meeting is being moved upstairs to room 3024.
Okay.
Thank you for your time.
Alexis, who was Mario? Okay, now we're going to call case number 2464. That is 2464 CESM, Georgina Mendoza and Javier Menduhana Figueroa. Sorry if I butchered those names. Were you sworn in?
I did
in
swear
the,
in.
okay, fantastic. And the respondent is not here?
Not here.
Okay.
Amy Curtis, E911 Administration Addressing Supervisor. I am presenting a copy of the presentation to the clerk and request it to be entered into the record.
Okay, if you'll go ahead and present your case first.
All right. Case number 2464 CESM is for the property located at 312 Fairmont Drive, Sanford, which is owned by Georgina Manduano Mendoza and Javier Mandujano Figueroa. The violation charged is Seminole County Land Development Code, Chapter 90.5A and 90.54. And the description of the violation is the address numbers are not posted on the structure. The case summary is, the initial inspection was 8/22/23. The notices were sent to the respondent 9/26/23, 10/23/23, 12/14/23, and 2/23/24. And then the compliance date and extensions were 10/26/23, 11/23/23, 1/15/24, and 3/23/24. And follow-up site visit inspections were 9/25/23, 12/13/23, 2/20/24, 3/27/24. And the violation remains on the property. The screenshot is the property appraiser website, shows that Georgina Manduano Mendoza and Javier Manduano Figueroa is the record owner of the property. This is the certified return receipt received for the notice for the hearing of the property. This is a photograph showing this is the photograph that says showing that the address numbers 312 are not posted on the structure as of 9/11/2024. Same picture. And then Seminole County Land, I don't need to go through this. This is
The code.
yeah, that's the code. Based on the testimony and evidence presented in case number 2464 CESM, it is determined that the respondent is the owner of record of the property located at 312 Fairmont Drive, Sanford, in Seminole County, as determined by the property appraiser record, in possession or control of the property, and in violation of the Seminole County Code Land Development Code, Chapter 90.5A and 4. Oh, goodness. All right. Further recommend that the special magistrate order the respondent correct the violation on or before October 9th, 2024. In order to correct the violation, the respondent shall post the address numbers 312 on the structure. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance.
Okay, I'm going to accept the electronic case file into the record. I'm going to find that the property owners were properly noticed to be here today, and they are not here. I'm going to find that sufficient evidence was provided for me to find a violation of Seminole County Land Development Code, Chapter 90, Section 90.5A and 90.54. For failure to have the proper addressing numbers posted on the structure on the property. I'm going to find that, or order that the property be brought into compliance by October 9th, or a fine of $250 a day will be imposed with a compliance hearing of October 10th. Thank you.
Thank you.
All right, the next case I'm going to call is 2447 CESM Armando Calero. Mr. Palomino?
Yes, Your Honor.
Okay.
I'm Armando's brother.
Okay. And I do, for the record, I see that there is an authorization from your brother authorizing you to speak on his behalf in this matter. Okay, I'm going to go ahead and swear you in. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Jason Rucker, Seminole County Inspector. This is case number 2447 CSM. Is located at 170 East 3rd Court, Juliota, which is owned by Armando Calero. The violation charge, Seminole County Code, Chapter 40, Appendix A, 105.1. Description of violation is interior and exterior construction to include pool enclosure and multiple structures on the property without the required permits. The initial inspection was done on October 17th, 2023. There have been several notices and extensions and compliance dates to the owner, follow-up inspections that were done, and follow-up inspections that were done by the computer, and the violation remains on the property. The screen shows that Armando Collier is the owner of record of the property. The next photos show that the property was posted. Okay, this photo shows some of the violation that still remain on the property. There's some interior photos, and there's some photos of the pool resurfacing. There's a couple shed-type structures on the property. The gazebo. Yeah, keep going. Gazebo on the property. Several pictures of stuff that it was done without permits. Looks like some wiring circuits were done to an AC unit. Looks like they've done some interior renovations throughout the house. In 2024, they got a demolition permit for the shed and the pool, and they got another permit that's currently in plan check for residential alterations, so they have applied.
So the demolition was for the pool?
Was for the shed and the pool, for a shed and a pool.
So to demolish the pool?
They can, yeah. They can take it out, fill it in, yeah.
And that's what that permit was for?
According to my notes, yes.
And it was issued?
It was issued. I don't know that it's been inspected yet, but it was issued.
We're waiting for the building department's pre-inspection.
But the pool is not demolished?
Not yet, not yet.
But we're here for no permit for the pool, but a demolition permit for the pool was issued?
There has to be a demolition because there's electric run to the pump, so we have to make sure it's demoed properly to be safe.
But if
she knows the demo hasn't been done yet.
But if the violation is because they don't have a permit for the pool, but we know they're going to demo it?
Correct. There's a lot of things that we have them pull demo permits for, especially if they have electric run to them, for proper termination so that it's not a safety issue. So if somebody goes out there and just says, okay, I'm going to demo the pool, they could leave a bare wire sticking up that's going to electrocute somebody. So that's not proper. So that's why the county requires a permit for that.
But are you going to fill the pool in?
Yes, ma'am.
Okay. But why would we violate them for not having a permit for the pool if we know they're going to demo the pool?
Well, the violation, I believe, was for the resurfacing of the pool and the screen enclosure.
Enclosure and multiple stores. So it's not for the pool itself,
Correct.
just for the pool enclosure, but if they're going to, are you going to demo the pool enclosure as well?
The idea is to leave the pool enclosure as it is.
Okay, so then you would need the permit for the pool enclosure then if you're going to leave it. Okay. Okay. Sorry, go ahead.
No. The next slide shows plan review comments in E-Plan for the permit that is in plan check. He's got several items that he needs to take care of. The next slide shows the code section that we cited. Based on the testimony and evidence presented in case number 2447 CSM, it is determined that the respondent is the owner of record of the property located at 170 East 3rd Court, Chuliota, in Seminole County, as determined by the property appraiser's record, and in possession and control of the property, and in violation of the Seminole County Code, Chapter 40, Appendix A, Section 105.1. It is further recommended that the special magistrate order the respondent correct the violation on or before 11/13/24. In order to correct the violation, the respondent shall obtain the required permits for the cited violations. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or are repeated after compliance. The respondent must contact the inspector to verify compliance. I have presented a copy of this presentation to the clerk and request it be entered into record. This concludes my presentation.
Do you have any objection to the electronic case file that has been presented to you being entered into evidence?
No objections, Your Honor.
Okay.
Okay. Basically, I wanted to give you an update on what has been done so far. We were able to hire a general contractor. We did a survey for the property, and I believe it was submitted to the building department. And additionally, we hired an architect to do the plans to convert the multifamily into a single family. That has been submitted to the building department as well.
So that's the next case.
Oh, okay.
The one that is before me right now is for the construction without a permit. And so what the county is basically asking is that you come into compliance by November 13th.
Okay.
Which is the day before the hearing in November. Do you have any concerns with being able to come into compliance and getting the permits for the construction by that time?
No, I think we're almost very close to. We're waiting for an inspection from the building department. To my understanding, the general contractor needs to schedule the pre-inspection and for the demo. So that's where we're at right now.
Okay. Then I'm going to go ahead and order that you bring the property, that the property is in fact in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1. In order that the property be brought into compliance by obtaining the necessary permits for the construction that's been done on the property by November 13th, 2024, with a compliance date, a compliance hearing date of November 14th, 2024. And if you do not comply by that date, there'll be a fine of $250 a day imposed. Okay. The next case, Kara, let's go ahead and do case number 2449 CESM, which is the next case.
Next case, okay.
Officer Hill, were you sworn?
No, ma'am.
Okay. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Officer Hill, Seminole County Sheriff's Office Code Enforcement East Region. This is case number 2449 CESM, Armando P. Calero, located at 170 East 3rd Court in Chuliota. Violation charge is Seminole County Land Development Code, Chapter 30, Part 11, Section 30.182, use is permitted. A multifamily dwelling is not a permitted use in an R1 zoning district. My initial inspection was on October 12th, 2023, with notice to respondent on October 17th and November 7th, 2023. Compliance dates were October 31st and November 21st, 2023, with multiple follow-up inspections, including this morning. The results of my inspection was the violation of a multifamily dwelling remains on the subject property. These photos were taken on my initial inspection on October 12th, 2023. These are the stairs that go on the outside of the residence to go upstairs, because there's no internal stairs on the inside of this residence. These photos were taken on the same date, and this is the inside of the multifamily dwelling upstairs. The photo on the left was taken from Redfin about August 20th, 23, and then after that, Mr. Calero purchased the property, and the photo on the right shows from August 12th, 23, the difference, and that there's no stairs leading to the main structure downstairs. These photos were taken on a reinspection on November 27th, 2023, no change. This photo was taken on January 5th, 2024, no change. These photos were taken on August 30th, 2024. These photos were taken this morning. The suggested recommendation is based on the testimony and evidence presented in case 2449 CESM. It is determined that the respondent, Armando P. Calero, is the owner of record located at 170 East 3rd Court, located in Seminole County, is determined by property appraiser's records, in possession or control of the property, and is in violation of Seminole County Land Development Code, Chapter 30, Part 11, Section 30.182. It is further recommended that the special magistrate issue an order for the respondent to correct the violation on or before October 13th, 2024, but if we want to move it to the same date as the building department, I would have no objection to that. In order to correct the violation, the respondent must convert the multifamily dwelling back into a single-family dwelling. If the respondent does not comply with the order, a fine of $100 will be imposed for each day the violation continues or is repeated after compliance. I would like to submit a copy of my PowerPoint into electronic evidence.
Do you have any objection to the electronic case file being submitted into evidence?
No objections, Your Honor.
Okay. And again, Mr. Palomino, I will accept you as acting on behalf of your brother, who is the property owner. Okay. Is the only thing that makes the dwelling unit a multifamily dwelling unit the fact that there are stairs on the outside?
So to make it into a single-family dwelling, they would need to have access from top to bottom and vice versa. So you would have to have access to the main living quarters downstairs, such as the kitchen, living room, etc. So the only access point right now is that stairs on the outside of the residence. So that's what makes it the multifamily dwelling. There's no access into the main residence.
Okay, and was this built on to the residence without permits?
Yes, and I believe Mr. Calero had purchased the sins of the previous property owner. So I believe that multifamily dwelling was there before Mr. Calero purchased the property. He just has updated it since.
Okay. And so are you understanding what needs to be done to correct the issue?
Yes, ma'am. As a matter of fact, I have here some plans that the architect built trying to solve that issue that Officer Hills brings to attention. So I would like to present those as a proof.
Well, those will be submitted, I mean...
Or they're already been submitted to the building.
Have they been submitted?
They have been submitted to the building department.
Do you want to take a look at them? I mean, are they?
I'm okay with them. I just was going to give them to you if
Oh.
that's what you needed.
If they've been submitted to the county, then they're in the county's record, and as long as you're working with them. Now, do we know, does he have the ability to do what he's trying to do by November 13th?
That would be a question for the building department with their permits and how fast that would work. And if the structure is able to, be built that way, I honestly don't know.
To my understanding, what the general contractor said is that there are two different phases. So the first phase would be the demo, like demolishing the shed and filling out the pool. And then after that, we can proceed with the other phase, would be converting the multifamily into residential R1 zoning.
Okay, so compliant with what?
Yeah.
Does anyone have any idea whether this can be done within basically 60 days?
I'm going to be honest, I don't ever recall seeing anything being submitted for this. Even if they're going to phase it, I would start plan review as soon as possible. Typically, they're going to have comments from building. They're probably going to have comments from me as far as zoning review, setbacks. I don't know what they've altered, so from the original footprint to even know if they're going to need variances at this point, if it meets building line. I don't know what they've touched from the original footprint. So 60 days to see if he's even gotten moving on it would be a good start, as far as if he's even submitted a building permit, and then we can give you a guideline from there as to whether he's going to need variances or anything additional. But I would think 60 days would be a good start, at least to show good faith in at least submitting a permit for the renovations to make the house compliant.
Okay. So one of the biggest things that you could go south on here is not maintaining communication with the county. Because as long as you're communicating with the county and they come here and testify that you're doing all of the things in your power to possibly do to come into compliance, then you're going to go smoothly through the process. But if there's ever a time where you aren't doing something that you need to do, then that's going to be where the breakdown is and where then I have to move forward with imposing fines. So I encourage you as quickly as you possibly can to get in and meet with both Jason and Kara to make sure you're doing everything that you need to do for the county to get both of these things done simultaneously. I'll go ahead and order that this particular case with respect to the changing the single family, making this a single family dwelling unit again instead of a multifamily dwelling unit, that I will order that be by November 13th as well. Okay. Or a fine of $250 a day would be imposed for each and every day thereafter that the property remains in violation. And I would just recommend that you maintained communication with them so that we can comply by this date. Yeah. And you can show your good faith working toward that compliance. Okay?
Good.
All right. Thank you.
Okay, thank you.
$2462 CESM, Mount Zion Baptist Church of Midway. Hello, sir.
Hi, ma'am.
Can you state your name, please?
Johnny Perry.
Okay. Can you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Jason Rucker, Inspector, Seminole County. This is case number 2462 CESM. Property located at 2001 Sipes Avenue in Sanford, Florida. Violation charge is Seminole County Code Chapter 40, Appendix A, Section 105.1. The description of the violation is installation of a structure without the required permits. The initial inspection was done on 8/22/23. The notice to the respondent was done on 8/22/23. There have been several compliance dates and extensions, as well as follow-up inspections via on-site and via the computer, and the results of the re-inspections are the violation remains on the property. This is the copy of the property appraisers that shows they're the owners of the church here. This is where we got the green card back from the respondents. And here are the pictures of the structure. Several pictures here to go through. There wasn't a permit that was applied for, but it was void due to exceeding the 7-day upload period. They didn't follow through with some of the requirements. The next page shows the actual code section we are citing out of Chapter 40, Seminole County Code. Recommendation: based on the testimony and evidence presented in case number 2462 CESM, it is determined that the respondents are the owners of record of the property located at 2001 Sipes Avenue, Sanford, Florida, in possession and control of the property, and in violation of the Seminole County Code, Chapter 40, Appendix A, 105.1. It is further recommended that Special Magistrate order the respondent correct the violation on or before November 13th, 2024. In order to correct the violation, the respondent shall obtain the required permits for the cited violation. If the respondent does not comply with the order, a fine of $50 a day will be imposed for each day the violation continues or is repeated after compliance. The respondents must contact the inspector to verify compliance. I have presented a copy of this presentation to the clerk and request it be entered into record. That concludes my presentation.
Sir, do you have any objection to the electronic case file, which is before you being placed into the record?
No.
Okay, I'll accept it. Do you have anything you would like to provide?
Yes, ma'am. As noted, we applied for a permit on the 13th of February, and it was voided on the 24th of February for lack of follow-up. And the lack of follow-up was from our contractor. And being novice, we didn't realize that until I spoke with Jason, and he told me that you all were in violation for not following up. So we were trying to get a permit, but it was voided, like I said, because the person that we entrusted, the contractor, he didn't follow up. He didn't let us know anything. So.
Okay. Well, what the county is asking now is that you get your permit and get everything going by November 13th.
Right.
So they're basically giving you 60 days to get that brought back up and going. Is that something you think that you'll be able to do?
Well, yes, we just have to resubmit the permit request, right? Yeah, and I don't see a problem with doing that. I don't know. Now, once we obtain the permit, though, permit would be for the the structure we already have, you can see it's already here, and we've fed hundreds of people on Wednesdays. Each Wednesday, we feed hundreds of people, and we take care of the homeless and.
And that's exactly why we want to get it permitted, so that we make sure that it's safe.
Okay.
And so you get it permitted, and then it would get a certificate of occupancy from there.
Okay.
But the main issue here is to get a permit,
Yes, ma'am.
okay?
Yes, ma'am.
Okay, then I'm going to go ahead and order that you are in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1, and order that you bring the property into compliance by obtaining a permit for the structures or the structure by November 13th, or I'm going to impose a fine of $50 a day.
Yes, ma'am.
Okay?
Mm-hmm.
Thank you.
Thank you.
Okay, the next case, 2463 CESM, Chad Bishop. Oh, he's not here? Did he leave?
No, I think it's.
Chad Bishop? Oh, okay.
Been here since 1, I promise I'm here.
Sorry.
Is this where I go?
Yes. I'm going to go ahead and swear you in. Do you solemnly swear or affirm the testimony that you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Go ahead.
Jason Rucker, Seminole County Inspector. This is case number 2463 CESM for the property located at 821 Largo Court, Apopka, owned by Chad Bishop. The violation charge is Seminole County Code, Chapter 40, Appendix A, Section 105.1. Description of the violation is the installation of new siding, soffit, and stone without the required permits. Initial inspection was done on 11/1 of '23. The notice was given to the respondent or posted on the property at 11/1/23. There have been several compliance dates and extensions given, follow-up inspections that were done on-site and via the computer, and the violations still remain on the property. The next screen shows the property appraiser's website showing that Chad Bishop is the owner of the property. We got the green card back saying that he received notice of the hearing. The following are pictures of the siding and the posting of the violation, the stonework out front, that it remains. These are different dates that were taken. There was a notice that had to be posted at one point on the property. Okay, and the only permit, there's been no permits pulled. There was a permit pulled in '21. That was the last permit on the property. Next slide shows the code that was cited, the Seminole County Code, Chapter 40. Based on the testimony and evidence presented in Case 2463 CESM, it is determined that the respondent is the owner of record of the property located at 821 Largo Court, Apopka, in Seminole County, in possession of control of the property and in violation of the Seminole County Code, Chapter 40, Appendix A, Section 105.1. Further recommend that the special magistrate order the respondent to correct the violation on or before November 13th, 2024. In order to correct the violation, the respondent shall obtain the required permits for the cited violations. If the respondent does not comply with the order, a fine of $50 a day will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. I've presented a copy of this presentation to the clerk and request that it be entered into record. That concludes my presentation.
Do you have any objection to the electronic case file that's been presented, being submitted into the record?
I don't think so. I just would maybe say that the word I would use would be enhanced. I feel like I just enhanced the exterior of the front of my house. I didn't add or build anything. So I just didn't know I needed permits, so I would do what needs to be done to suffice this. And
Okay, so do you have a problem with me accepting the electronic case file, the information that has been provided to you, submitting it into the record?
no.
Okay,
No.
I'll accept it into the record, and I'll also accept that you didn't understand that a permit was needed, but when you received the various notices, did you try to make contact?
I did. I reached out and I came out here a couple times, and I just feel the lingo was hard to understand. And then playing what self-contractor myself was intimidating with some of this paperwork. Basically ran into a financial standstill. I couldn't finish the project. And so here I am. Whatever needs to be done, I'll do it. I just kind of confused on the process.
Okay, so can he come in and have someone help him through filling out?
Absolutely.
Okay.
We'll be able to help.
Okay, so they're asking that you get all of the documentation filled out to get your building permit for the work that you've done that will ultimately lead to you getting the certificate of occupancy for what you've done by November 13th. Do you
Okay.
think you can do that? It's almost 60 days
Yeah,
for
I
you
should
to.
be able to handle that.
Okay,
Yeah.
and they will walk you through the process.
Yeah, that's kind of what I need, is some guidance and just make sure I'm not doing the wrong thing, I guess.
Okay, and they don't want you to be intimidated by the process. They want to help you through it and make sure that you understand everything that you are committing to.
Right.
So, okay, so I'm going to go ahead and order that you are in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1, for failure to have the necessary building permits for the enhancements on your property.
Keyword.
I'm going to order that you bring the property into compliance by obtaining the necessary permits by November 13th. And if you do not comply by November 13th, there'll be a fine in the amount of $100 a day imposed. You will have a compliance hearing date of November 14th. But of course, if you're in compliance, you don't need to appear on that date.
All righty.
Okay?
Cool.
Thank you.
Thank you.
2162 CESM, Nyla Thompson. Oh, no, American Federated Title Corporation. Nyla Thompson is the individual here. So do you have anything indicating that you're permitted to speak on behalf of the property owner?
Well, they are holding me fully responsible as the tenant.
Okay, and what company do you work for?
I own Soapy's Dog Wash.
Okay. And that's S-O-P-H-I-E?
Soapys, Soapy's.
Oh, Soapy's. Okay. All right. Let me go ahead and swear you in. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Go ahead.
Jason Rucker, Inspector, Seminole County. This is case number 2162 CESM, American Federation Title Corporation, Franklin M. Esmail, located at 3060 East SR 436, Apopka, Florida. Violation charged, Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permit. This case was originally heard by Special Magistrate on April 14th, 2022, and an order was issued giving the respondents a compliance date of June 9th, 2022. On June 9th, 2022, Special Magistrate issued an order extending the compliance date to August 11th, 2022, An affidavit of noncompliance was filed by the inspector after reinspection on August 11th, 2022. On February 9th, 2023, Special Magistrate issued an order imposing that for 182 days of noncompliance. An affidavit of compliance was filed by the inspector after reinspection on July 15th, 2024. The administrative cost processed by the clerk was $270.72. Administrative cost to process this case for the inspector was $536.93 for a total of $807.65. We recommend the special magistrate issue an order imposing a lien in the amount of $35,250 for 105 days of noncompliance from August 11th, 2022 through and including July 15th, 2024 at $50 per day. And a fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after September 12th, 2024. That concludes my presentation, and I would like this to be submitted into record.
Okay, do you have an objection to the electronic case file being submitted into the record?
It doesn't seem like everything that he said is on here, but, and I just don't think I really understood that last part. If I'm in compliance, why would the fines continue? But
So the fines didn't continue. They were imposed.
February 9th, I know. It's since February 9th.
So you were ordered to bring the property into compliance by August 11th. And at what point, I guess I'm a little confused. At what
It
point
is
was the
confusing.
property actually complied? It says here, July 15th, 2024. Okay, the permit was
obtained July 9th.
of 2024.
Yes.
Okay, so do you have any idea what took so long?
Oh, yes, ma'am, I can answer that. I had to get a second contract. It was very, first of all, the reason for the problem was I had rented the unit next door to me, and I had hired a company to open the walls between my two units, which is what I did. And I had I hired someone to do that, and obviously they did not file a permit for that. It was simple to me that they just opened the walls. There wasn't anything added or done. But because of the opening of the walls, they found me in violation, of course, of doing this without a permit, but it also did a change of occupancy, and they held me responsible for every single thing that had been done to those units prior to me even leasing those units. From the ground to the roof, they wanted documentation of every single thing in there, and they did not have any permits from any of the leaser people before me. So like a dentist had put in drains in the floor, they didn't have any permits for that. It was a constant back and forth thing of what they were requiring from me. The first general contractor I hired failed me in this process because it was just too encumbersome, and he wasn't being able to follow up with all the demands. And I know there was an awful lot of back and forth between the contractors and the county. I know I've spoken with them many times myself and have been there many times myself. As far as so their requirements were very excessive in that I did very little when I moved into the unit. I did very little, and yet they wanted me to document the air conditioning vents, the lighting, the the electrical, the plumbing, everything.
And what kind of involvement did the property owner have in this with you?
None. They have helped me very, very little.
Okay, so that's the problem that I'm having with this. Not that you've done anything, but the property owner has.
Well, in my lease agreement, they hold me responsible.
But you're not, and I certainly do not want to provide you and am not providing you with legal advice, but if some of the things that you were required to do for the permitting process were things that were for prior tenants, you might want to seek the advice of someone related to that, because the property owner is responsible. And it's a shame that they have sent you here.
They put it in the lease that I'm responsible for any required permits.
For what you do, though.
Right. But unfortunately, like I said, they said, though, because I opened the walls, it created a change of occupancy. And that's why they had to go back to me documenting the entire premises. I have spent well over $30,000 of money I will not make a profit on in architects and constructions and fines and fees and trying to be compliant. I am, as you know, just a groomer there, but I have been there for 17 years. But really, I moved in, I put my grooming tubs right into the existing plumbing. I didn't do anything to the air conditioner. I didn't add any electricity.
You've been at this location for 17 years?
Yes, ma'am.
Who was the tenant prior to you then?
I really don't, just before me, it was a daycare, and then before that, when I lived in the area for over 25 years, I went to a dentist that was in that office that I'm leasing, and that's why there was plumbing and drains already in the floor for those dental chairs that required water, which made it easy for me to move in because it had that equipment already there. I didn't have to add the drains to the floors or any plumbing or anything because the dentist had already done that. I just put in my grooming tubs.
And so there weren't permits for any of those things?
They couldn't find permits for any of it. The landlord couldn't find permits and the county couldn't find permits. And so they've held me responsible for all of it. And it's literally this fine will put me out of business, and I have 10 employees. I employ a deaf person, a blind person, senior citizen, a black person. I have been there for 17 years. I'm well loved in the community, and this will definitely put me out of business. If not bankrupt me too, because the landlord will hold me responsible for the lien that you impose. However, the good news is it's in compliance. I just need an inspection now.
Wait, you don't have an oh, you're going through that
The
process?
permit has been issued, and now I'm just going to order an inspection because, like I said, the work was previous to me being there. I mean, I painted and I've tiled the floor, but that's normal.
So achieving compliance
was very difficult.
Well, it's what my objective is. And I certainly am not in the business of putting long-standing businesses out of business.
I inherited this case, so I don't know it 100% like I should. So I don't know what was in there before.
They couldn't find out. You did research. They did research. They couldn't find, oh, well, there is a dentist there, but the dentist is the one who, I know the dentist is the one who put in the plumbing, but he did not have a permit for it.
So
It looks like there was a florist in there at one time in '06.
But right before I took it, it was a daycare, an after-school daycare thing, which isn't on there. It was like there was really, the history was very poor, and permitting that was, people had done to it. It's a very old building. But I moved into it because I knew the dentist had put the plumbing in, and there was already drains in the floor, which made it real easy for me to put my dog business in there.
In the pictures that I'm seeing from 2022 that were part of this packet, that's what it's always looked like since you moved in?
Yes, I didn't do anything to alter the only thing I did was see that opening right there is in the wall that goes between.
That's where it was
I
opened.
opened that, which didn't require any moving of plumbing or electric. I didn't, nothing. There was nothing in there. It was just a wall, and I opened the wall between the two units. And in that other unit, all I did was put standing kennels. So see those drains, all that was already there. I just plumbed into what was existing. And then there's another opening that you don't see in these pictures in the back. So I made 2 openings in the wall, which is what caused this whole, and I hired people to do that. I didn't do it myself, obviously. Yeah. That's, you can barely see the second opening in the corner where you see the yellow wall. That's the second opening. I made those 2 openings in the wall, which is what caused this all to befall on me. In the landlord renting me the unit next door so I could expand.
And my struggle is that the landlord is just getting away with.
That's what they do there. If there's something wrong with the Havoc unit on the roof, it's my responsibility. It's a $65,000 frickin' air conditioner up on the roof that they hold me responsible for too. But it is in my lease that I am required to get all necessary permits. So this does fall on me legally in my lease, at least as far as I can see. But you're right, I didn't hire an attorney. Instead, I've been hiring architects. And
the other thing about it is I don't know the history of the case either because I wasn't the magistrate at the time, so it's hard for me to.
COVID hit us, and it hit us pretty hard. It hit me very hard. I lost my mother and my brother and had to take in my senior father who recently just passed. So I have been burdened with a lot besides this as well.
Okay. So
I just want to move. I just want to keep my business if possible. I've been there. I'm well loved in the community.
I'm going to, you need to get your final inspection and you need to get your CO for what you've done. So please do that.
Yes,
Get that
so
inspection
I
and
think they're ready
finalized.
now to, the final straw that's holding me from calling the inspection was we had to get a mechanical engineer to sign off, and trying to get people to sign off on work that was already done. Everyone has refused me, and I have to pay thousands of dollars just to get them to sign on the permit for work they never even did. And the last one I'm trying to do, Jace, I think he contacted you this week, an air conditioner. I don't know if he's signed off yet or not. He didn't tell me if he was going to. But he was my 3rd mechanical air conditioner guy that I'm trying to get to sign off for me.
So what I'm going to do is I'm going to waive the fines, but I'm going to impose fees and costs, okay? So I'm going to impose the administrative costs in the amount of $807.65, okay? And I'm going to ask that you pay that within 30 days, okay?
Yes, ma'am.
If not, it will be imposed as a lien
Please,
against the property.
I'll do that.
Okay. And you can let your landlord know it's their lucky day.
No, believe me, you wouldn't believe the conversation she gave me yesterday.
Okay, so that's what we'll do. Thank you.
Thank you. Thank you. Thank you. Thank you so much. I hope that I'll be able to get the inspection done.
Yeah, you need to turn in the notice of commencement, and then they can schedule the inspection.
And that would be my construction, like I said, we needed that last signature off of the mechanical engineer. Thank you.
You're welcome.
2346 CSM Rico Properties. Is that, he's not here any longer?
He was out there. Yep, here he comes.
Oh, okay. Sorry.
For me, you're so kind.
Go ahead and swear you in. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Jason Rucker, Seminole County Inspector. This is case number 2346 CESM, Rico Property LLP, Brian C. Reese, registered agent, located at 2710 Pemberton Drive, Apopka. The violation, Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permit. This case was originally heard by Special Magistrate on July 13th, 2023, and an order was given to the respondent to comply by September 15th, 2023. Affidavit of non-compliance was filed by the inspector after reinspection on September 19th, 2023. On November 20th, 2023, Special Magistrate issued an amended order extending the compliance date to January 10th, 2024. On January 11th, 2024, Special Magistrate issued an amended order extending the compliance date to March 13th, 2024, with a compliance hearing scheduled for March 14th, 2024. March 14th, 2024, Special Magistrate issued an amended order extending the compliance date to June 12th, 2024, with a compliance date for scheduled hearing on June 13th, 2024. An affidavit of non-compliance was filed after reinspection on June 12th, 2024. On June 13th, 2024, Special Magistrate issued an amended order extending the compliance date to August 21st, 2024, with a compliance hearing scheduled for September 12th, 2024. An affidavit of non-compliance was filed by the inspector on August 22nd of 2022 after reinspection. The administrative cost for the inspector on this case totals $608.84. The administrative cost for the clerk on this case totals $380.82, for a combined total of $989.66. Recommend that the Special Magistrate issue an order constituting a lien in the amount of $1,150 for 23 days of noncompliance from August 21st, 2024 through and including September 12th, 2024 at $50 a day, and the fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after September 12th, 2024. I request that this be entered into record, and that concludes my presentation.
Do you have any objection to the electronic case file being submitted into the record?
No.
Okay, I'll accept the same.
Hi.
Hi.
Good to see you again, Judge. Since we last spoke, we have, I had applied for a PD minor, and it actually turned into a PD major. On July the 26th, we had to amend it to a PD major, which my understanding from Caitlin, the planning, one of the planning directors, that it's going to take 6 to 9 months. So I would respectfully request a 6 to 9 month enlargement of time so we can keep moving forward. And since the last time you and I spoke, which I'm sure you're glad to see me again, but since the last time, we have completed several things. We've gotten our stairs, we've permitted and installed. We have completed our HVAC, our mechanical and plumbing. We are awaiting final inspections on both of those. We have to do another test and balance for the mechanical. And we're going to have that hopefully next week. And once we have that, we can reapply for an inspection of that, and we will pass. This is the second time we've had it inspected, and we did everything that the inspector wanted us to do the first time, but then something must have changed, and we had to do some other things, and we've since corrected what he was objecting to.
Okay, so what's before me is just the construction of the exterior canopy without the required permits.
Well, there's several issues going on there, but I guess the carports is part of the PD major. That's what we had to apply for the PD major for.
Okay.
But we have other issues going on. What happened was,
I don't have violations on these other issues.
No.
Go ahead.
Correct.
Okay, so.
Yeah, there was interior work.
Okay, so whenever they touch the exterior of a commercial site, it can trigger a site plan, and then it depends on how much of the exterior they're altering, whether it's a minor or a major site plan amendment. Because this is a plan development, he's having to do a minor or a major amendment.
Oh, so he's amending his PD zoning.
Correct. It went from a minor to a major.
So not only is he going to have to do the amendment, then he's also going to have to do his site plan.
Well,
Okay.
we submitted a site plan, and
So hopefully all of it's contained within the amendment for the PD, and it all ties up with a nice little bow. But Dale and I were just talking about this. 6 months is probably a good time frame to bring him back, make sure he's moving through the process smoothly, and that everything's still moving along and tracking. Because sometimes in zoning, there can be huge lags of communication between consultants that are applying for these projects. If the applicant doesn't have view rights and isn't actively staying on top of their consultants. So it would be great to kind of touch back in. You can request view rights on your project. Reach out to the girls upstairs at Central Intake Desk. They can give you view only to make sure that you're tracking it.
okay.
I can give you my card before you leave, and I can get you in touch with
Watch
them.
out, I'm just going to take it too.
So that we can get him view only. That way he can track the progress of his project, so that if they're not actively communicating back with Caitlin through the project, that he can get back to his consultants and make sure that they're doing what they need to do and getting her whatever documentation she needs to satisfy the multiple reviewers during that process.
Okay.
So
and
he can push it along.
Okay, and I definitely see in my original order that there were interior renovations that were done as well, in addition to the construction of the canopy. So all
Right,
of those
which can
things, he's worked on
trigger
those.
Parking requirements, I mean, depending on what they're doing, it could be, that's why I'm saying 6 months would be a great.
Sure, but my point is that, that he's complied along the way with various things that he's working toward compliant. He's been in communication with you all along the way.
Yes.
Okay. It doesn't upset me to continue to amend if you're doing that, as long as you're moving through the process. So
Thank you.
I appreciate that staff has indicated the amount of time that they think that that it will take you, but at the same time, being mindful of, if you're not going to, if you stop working through the process, that of course, that's a problem. So approximately 6 months gets us to the March 12th, 2025 meeting. So what I'll do is I'll continue the compliance date for all of the various things, which ultimately will lead you to be able to get the permit that you need for construction.
Yes, ma'am.
So I'll make your compliance date now, March 13th, 2025. March 12th, sorry.
March 12th?
March 12th, 2025, with a
cut me a
compliant,
day.
with a compliance hearing of March 13th.
Could I also add one more thing? I forgot to mention that in applying for the PD major, we've completed, or we've been approved by all the different planning departments except for Caitlin, and we're working on that one. Additionally, I'd like to say that in regard to the parking, we've got the parking taken care of, and something else. It'll come to me in a minute, but we've done a lot.
Okay, well,
Well, the point of me telling you that is I want you to know that we're working in good faith to make sure that we're doing what we need to do.
well, and I see that you are, because if you've gotten those permits approved for the interior, I think that says a lot, because because when we initially were here, there were several things.
It was a mess, yes, ma'am.
So, okay. Then we'll go ahead and extend the compliance date to March 12th, 2025, with a compliance hearing of March 13th, 2025.
Thank you kindly. And in regard to the fines?
There's a new compliance date, so you have no fines yet.
Perfect.
Thank you.
Thank you.
That worked out.
We're out of people. Oh, no, I'm sorry.
If I may, Your Honor?
Yep, what?
Case 2453 CSM.
Okay.
May I approach the?
Sure. 2450.
That would be.
Okay, I'm sorry. You didn't check in. Next time? Oh, you did? Oh, I don't have it on mine. It's blank. So, see, I didn't know you were here this whole time.
I apologize.
You might have been called a lot sooner. Sorry.
Thank you.
No, I'm here.
Oh, okay.
Because I saw Michelle Garcia, Barkley.
Okay. Well, yes, you're on here. So, I'm sorry.
It's okay.
Good evening, everyone.
Hello. Okay. Mr. Iceman?
Yes, ma'am.
Okay. Will you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay.
Jason Rucker, Seminole County Inspector. Excuse me. This is case number 2453 CESM. Is for the property located at 3314 Curtis Drive in Apopka, which is owned by BAF Asset 3 LLC. The violation charges the Seminole County Code, Chapter 40, Appendix A, Section 105.1. Description of violation is installation of a wood privacy fence without the required permits. The initial inspection was done on November 8, 2023. The notice to the respondent was November 9th, 2023. There have been several compliance dates and follow-up inspections via the computer and on-site. Next sheet shows that BAF Asset 3 LLC is the owner of record of the property. The next sheet shows where the property was posted for this hearing. The next slides show the fence that needs to be permitted on both sides. And the next slide shows as well the notice of code violation. Some follow-up inspections that were taken, pictures. This screen shows that there have been no permits applied for. The next slide shows the code section that we are citing them for, Chapter 40. Based on the testimony and evidence presented in case number 2453 CESM, it is determined that the respondents are the owners of records of the property located at 3314 Curtis Drive, Apopka, Seminole County, in possession and control of the property and in violation of Seminole County Code Chapter 40, Appendix A, 105.1. Further recommend that special magistrate order the respondent to correct the violation on or before November 13th, 2024. In order to correct the violation, the respondent shall obtain the required permits for the cited violations. If the respondent does not comply with the order, a fine of $50 a day will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. I have presented a copy of this presentation to the clerk and request that it be entered into record. That concludes my presentation.
Do you have any objection to the electronic case file being submitted into the record?
I have one objection, I believe. I believe yesterday a permit was filed for the fence.
No.
Okay, I will take that up with the general contractor. I do have copies of,
They were here, but they weren't registered, so they couldn't pull a permit.
yeah, he did mention something of that sort. He
Okay.
did say that he applied to be registered. I'm not sure of that process or how long that does take. I was under the understanding that he was able to actually register.
I believe he can register online. He's good now? Okay.
I'm
He needs
sorry,
to
say
apply
again?
online. He needs to apply online. He can apply for his permit online, once he's registered.
How long does that process take, if I may ask?
It depends, usually, for a fence, usually within a week, maybe 2 weeks if they're really busy, but
No, I meant him registering as whatever he
I
needs.
don't have any idea about registering.
He's registered now, is
He
what they're
is.
saying.
Okay.
Okay.
So maybe what he told you, he needed to register. He registered, now he needs to apply for the permit again.
Okay. I do have evidence, if I may present.
Sure, but do you have an objection
No,
then? to the-
other than that, no.
Okay, so I'll accept the electronic case file into the record. And can you, for the record, state your name and affiliation?
Yes, Joseph Edward Eisman. I'm a property manager for Main Street Renewal. We are the exclusive property management company for this ownership.
Okay, and Main Street Renewal?
Yes,
Okay,
Main Street is one word, renewal is the second word.
okay. And is there like a incorporated or anything behind it, or is it just Main Street Renewal?
Main Street Renewal.
Okay, are you,
It's a property management company.
and are you the owner of the property
No,
management
no,
company?
I
You
am-
just employed by the property management?
Correct.
Okay,
I'm an agent of ownership.
okay, okay. All right, go ahead.
This particular fence, I believe, was damaged with the hurricane last year at Adalia, I believe. Without my knowledge, that fence was repaired, which I believe is the section of fence, which is the right-hand side. Correct me if I'm wrong on that.
I'm not sure. I
Okay.
inherited this case. I
Is
just
there
go
a
off the
permit
picture.
for the fence at all?
No, not that I'm aware of.
Okay. We did purchase this property, I'm sorry, my company purchased this property back in, hold on,
Wait,
September of 2020.
your company or BAF Assets?
I'm sorry. BAF Assets purchased that company in 2020, September, is my understanding.
Okay,
That fence was in place upon purchase of that property. That was not added on after the purchase. My understanding is the fence was damaged during Hurricane Adalia last fall and had been repaired at some point prior to November 8th of 2023. We were a bit confused on our end as far as what was needed to rectify the situation. By the time we became aware of it, the fence was already repaired and in place. It seems to be the damaged area was the full right side of the fencing that was replaced.
okay, I think what they're telling you is that the fence has never had a permit, period.
Yeah, I understand that now.
So,
We were not aware of that prior.
Okay.
I apologize. The photos that we had seen, and I apologize, I don't get the original copies, which are in color. I get black and white photos, so you can't really tell very, very much. The photos presented to us did not depict a new fence. What we saw was an old aged fence, which was the other sections of the property. at some point in time, which seemed to be August 2nd, we were informed that we still needed a permit for the 6-foot wood fence nude sections. A demolition permit was going to be needed. And since there was a child-proof fence installed, we needed a pool safety form, affirmation form submitted as well, along with a permit for the fencing. We had a vendor which has applied for registration. We've reached out to them for a number of updates over the course of this incident, and only yesterday did they, I guess, try to come to fill out any applications. So the application I do have in front of me, the copy that I've been given, does not seem adequate and doesn't need to seem like it needs to be resubmitted. I'm now informed that we can submit online. So I will follow up with the vendor and get this corrected. My understanding, I believe, is we have to have that done no later than the permit issued by November 13th. Is that correct?
That's what the county is asking.
Yeah, I believe that will easily be done.
Okay, then I'm going to go ahead and find that you are in fact in violation of Seminole County Code Chapter 40, Appendix A, Section 105.1. I'm going to order that you bring the property into compliance by securing the necessary permits for the fence by November 13th, 2024. Or you will have a penalty imposed of $250 a day for each and every day thereafter that the violation remains on the property. You'll have a compliance hearing on November 14th. If you're in compliance, you will not need to appear at that hearing.
I do have a question.
Okay.
At one point in time, I believe in December 27th, a barrier fence was installed, and we didn't quite understand why that was needed when we had a wooden fence already in place.
To protect the pool from kids going back there and falling into the pool.
If
You
a
gotta
wooden
protect the
fence
pool.
is already on the perimeter, thank you, perimeter of the property, wouldn't that suffice in protecting?
I didn't see it, I wasn't there, I don't have pictures of it, so I can't answer that. So if there was a section of the fence that was damaged, or if there was.
I think it might be best if you go into the office and speak with the building department, and they'll talk through with you why something is necessary or not, so that you can get that part of this process, because that will be all part of this that will be need to be done ultimately, but just the permitting is what you're here for today.
Correct, and I do have one more question, if I may. As far as what's required, because prior to this, we've been informed, and I do have an email copy of it, that we had to have a demo permit for the fence, and I'm not understanding that logic. Yesterday, the vendor was informed that they don't need a demo permit, so it has not been clear on what is required.
We were told that the fence was removed completely from the property, so a demo permit would have been required to have the temporary fence put up until the new fence was put up. So if the fence was never removed, like I
Correct.
said, I inherited this case, I don't know the
Okay.
100%.
So we no longer need a demo permit?
To my knowledge, no. If you're protecting that pool, you do not.
Okay, thank you very much, I appreciate that.
Okay, thank you.
Thank you.
And let's go ahead and case number 2414 CESM, Michelle Garcia. Ms. Garcia, if you'll go ahead and raise your right hand. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Jason Rucker, Seminole County Inspector. This is case number 2414 CESM. Michelle Garcia, location is 2202 Barkwood Court, Lake Mary. A violation, Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the Special Magistrate on March 14, 2024, and an order was issued giving the respondent a compliance date of May 8, 2024, with a fine of $150 per day to continue to accrue for each day the violation continues or is repeated after May 9, 2024. On May 9, 2024, an order was issued extending the compliance date to September 11, 2024, with a meeting scheduled for September 12, 2024. The total administrative cost process for the clerk in this case was $133.60. The total administrative cost for the inspector in this case was $661.46 for a total of $795.06. Recommend that Special Magistrate issue an order constituting a lien in the amount of $150 for 1 day of noncompliance from September 11th, 2024 through and including September 12th, 2024 at $150 per day, and the fine shall continue to accrue at $150 per day for each day the violation continues or is repeated after September 12th, 2024. I would like this to be submitted into record. That concludes my presentation.
Do you have any objection to the electronic case file being submitted into the record?
No, ma'am.
Okay, I'll accept it. So, do you have anything to add?
I'm almost there. The fence being one of the things that finally got the permit, we finally got the permit issued. From my understanding, my contractor, he says he was having issues with the county. I think he was probably more, he was probably more the issue. I've been having some issues with it myself, but that was issued. I had the inspection scheduled for today. I didn't have the stamped survey ready, so they put the $50 penalty. I paid it immediately and rescheduled the inspection for tomorrow, and now I have all the forms ready to go for the inspector for tomorrow. So the fence should be cleared up here shortly. As far as the exterior door, that's been a little bit more of a frustrating process as far as getting an engineer, the engineer that I sent the plans over to you, but those weren't sealed. And trying to get the engineers to send the sealed plans to put into the permit application with the new contractor that I'm working with, which took a minute to find. He put those in today. I finally got sealed ones today. He said he put them in, it was like late morning, early afternoon. But that was the only thing that was missing but it's still in plan check, the alteration permit, but that's what the holdup was. I had him delay while I was trying to get those plans, the sealed plans, actually submitting the application, because he explained to me that it would take he would have 6 days to submit that before we'd have to start all over. So by the skin of our teeth, we got the sealed ones in today.
Do you have information of
I do have
those?
that here, just in case.
You submitted them to the county, or you?
My contractor submitted them to the county today. I didn't submit it personally, but my contractor did. It's just an application, and it's he was waiting on me to provide the sealed plans from the original people, which has been a nightmare.
Megan Zanorski, for the record, currently looking. Looks like some documentation was uploaded today. Looks like there are some plans that have been uploaded. Whether or not they're sufficient for review, I don't know. There does look like there might be a site plan. I might have to get with you.
Okay.
To get a survey similar to what we did for the fence, just to finalize.
Oh, I have a
out.
survey here too.
So, but I have your email. We worked on that together to take care of your fence. It does not look like it has been submitted.
What is the difference?
So it looks like he's uploaded, but he has not submitted the task yet, so he may not have all the documentation ready to submit to the county for review. I'm getting into that report right now. Bear with me. It just takes just a second to get into from screen to screen. It's a little slower down here in the chambers. Okay, so it looks like it's sitting with the permit text at submission, so it has been submitted. It was submitted 6 hours ago. And they are delayed from the large influx of permits that come in. So that's about accurate. It'll probably be routed out to me tomorrow for review.
And she's been working with you along the
I
way?
have not heard anything from her regarding this permit. I worked very closely with her initially to get the fence permit issued, and before Vicki went out, I had touched base with Vicki to see if she had heard anything after the fence. Jason and I had not heard anything since. So this is really the first that I've had any inkling that we were getting anything submitted. I mean, I'm glad it's submitted, but this is the first that I knew anything was coming our way on the edit or modification.
Okay.
So I have been bad about that. This whole thing has been incredibly stressful because I have been in the process of trying to move out of my home after not being there for so long. But regardless of all of that, what my holdup was in getting any of this, started as far as, something that has a paper trail. I was trying to get the original contractor. Last time I came in here with the belief that the contractor that I was working with had submitted an application that I wasn't permitting. I was ignorant in the fact that I didn't look online like I know I can now to verify that an application was actually in process. And when I came here and I'm thinking I had this notarized notice of commencement that I was told by the contractor, here, sign this, I'm thinking everything's going swimmingly, and then coming here and being told that that is just a piece of paper. So I was going back and forth with them for a while trying to get them to pull the permit like they originally stated they would. And they're connected to the engineer with the plan. So then I started trying to fill out the paperwork myself. I got very frustrated and confused. I reached out to Jason, and he was very helpful. I just was still I felt like I was being bothersome. So at that point, finances, were a little bit better. So I decided to go ahead and just hire somebody to handle this. And that's the company that submit that now. And they've been great. They've explained a lot of things to me. They were a huge help in advising me on how to kind of talk to them to talk to the engineer side of things to get the permit. To get the sealed version of the plans, because I'd given them plans that I was provided, but they weren't sealed. So it's just been a lot of, hoping that these people that are going to follow through on things that they said they would, and then, kind of sitting and waiting and hoping that was actually going to happen, and then having more back and forth. And it's just been, it's hard to get people to sign off on stuff that they weren't originally involved with. But.
Okay, so.
I will say this, my house is under contract to sell. I'm obviously going to need an extension on that, but there's no shortage of, I'm very aggressively trying to see this through, and doing everything I can.
Okay, so I need you to remain in contact with them.
Yes.
Because it's been submitted, I'm going to extend your compliance date till tomorrow at 5 p.m. if you do not do everything that you need to do, we're going to be back here on October 10th for a compliance hearing date anyway, because the county has incurred fees and costs related to this. So you may not have a penalty imposed, but you're going to have some fees and costs associated with this anyway. But you have a compliance date now of September 13th at 5 p.m.
So what do I have to be in compliance with this?
Obtaining your permit.
Okay, so if it's in plan review and this is the first time, my understanding, he's told me that there's likely it's gonna come back with something. So is there any way I can get a little bit longer than that? Because I can only
We haven't
move.
really had a chance to look at anything, and we can't do it in a
So
day.
how long would it take you all to review? Are you,
I'm going to say at least 2 weeks.
okay. Then what I'll do, because the county is going to need longer, I'll change your compliance date to October 9th, which
Okay.
is the day before, then you'll be back here on October 10th for a compliance hearing.
Okay.
So I will continue, so you'll have more than a couple days. October 9th will be your compliance date. If you do not comply by October 9th, you'll have a fine imposed of $150 a day. But if
Okay.
you're in compliance, then you're fine. But we will be back here for a compliance hearing on October 10th.
Okay.
Okay?
So I will, you said it's going to take up to 2 weeks to have this initial submission reviewed?
Could possibly.
Okay.
Maybe sooner, maybe a little bit longer.
Okay. Okay.
Okay. So we are continued till, on this case, till October 9th.
Okay.
Thank you.
Thank you so much.
Now I think we are out of people in the audience, so let's just start from the beginning. 2460 CESM, Annabelle Fernandez.
Jason Rucker, Seminole County Inspector. This is case number 2460 CESM, Annabelle Fernandez, located at 1982 Longwood Lake Mary Road. Violation charge is the Seminole County Code, Chapter 40, Appendix A, 105.1. Description of the violation is installation of a wood fence without the required permits. The initial inspection was done 11/8/23. Notice to the respondent was 11/8/23. There have been several compliance dates and extensions. Follow-up inspections have been done via the computer and on-site, and the violation remains on the property. Next screen shows property appraiser's website. That Annabelle Fernandez is the owner of record of the property. The next slide shows that the property was posted on 8/29/24. Next photos show that the fence remains on the property. Several photos there of the fence, 6-foot wood privacy fence. Photos of the fence and posting violation. Return mail taken, that was back in December. More photos. This is the screenshot showing that there was an application received in 2023 to correct the violation, but the application is currently under review and has not been issued. Next is a copy of the date it was applied for, 11/17/23. Correction notes on the next slide. Next slide is the section of code that we had cited them for. Recommendation is based on the testimony and evidence presented in case number 2460 CESM. It is determined that the respondents are the owner of record of the property located at 1982 Longwood, Lake Mary Road, Longwood, and in possession and control of the property, and in violation of the Seminole County Code, Chapter 40, Appendix A, 105.1. It is further recommended that special magistrate order the respondent correct the violation on or before November 13, 2024. In order to correct the violation, the respondent shall obtain the required permits for the cited violation. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. I have presented a copy of this presentation to the clerk and request it be entered into the record. This concludes my presentation.
I'm going to go ahead and accept the electronic case file into the record. I'm going to find that the respondent was properly noticed to be here today and is not present. I'm going to find that there has been evidence submitted that the property owner is in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1, for failure to obtain the necessary building permits for installation of a wood fence. I'm going to order that the property be brought into compliance by October 9th. And I'm going to impose a fine of $150 a day if the property is not complied with by October 9th. Okay, next matter, 2408 CESM, Julian Jimenez.
Jason Rucker, Seminole County Inspector. This is case number 2408 CESM, Julian Jimenez, located at 105 Sage Street, Altamont Springs. Violation, Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This order was originally heard by Special Magistrate on March 14, 2024, and an order was issued giving the respondents a compliance date of May 8, 2024, with a compliance hearing scheduled for May 9, 2024. On May 8, 2024, an affidavit of noncompliance was filed after reinspection on May 8, 2024. On May 9, 2024, Special Magistrate issued an order extending the compliance date to June 12, 2024, with a compliance hearing scheduled for June 13, 2024. On June 13, 2024, Special Magistrate issued an order extending the compliance date to August 21, 2024. With a compliance hearing scheduled for September 12, 2024. An affidavit of noncompliance was filed by the inspector on August 22nd of 2024 after the reinspection. The administrative cost to process this case for the inspector totals $894.48. $894.48, and the administrative cost to process the case for the clerk totals $181.26, for a total of $1,075.74. Recommend the special magistrate issue an order constituting a lien in the amount of $5,750 for 23 days of noncompliance from August 21st, 2024. Through and including September 12, 2024, at $250 per day, and a fine shall continue to accrue at $250 per day for each day the violation continues or is repeated after September 12, 2024. I request that this be submitted into record, and that concludes my presentation.
Okay, I'm going to verify for me, Alexis, that the property owner received the order, my order of June 13th, 2024. with a compliance hearing of today for September 12th. Okay, I'm going to find that there is a signed green card for my order dated June 13th, 2024, that the respondent is fully aware of the compliance hearing scheduled for today for September 12th, 2024. I'm going to find that there is evidence been presented that the property owner is not in compliance as of this date. I'm going to impose the fine of my prior order as of August 21st, 2024, of $250 a day, which penalty will continue for each and every day after August 21st, 2024, that the violation remains. I'm going to impose administrative costs in the amount of $1,075.74 to be paid within 30 days of the date hereof. And my order can be recorded as a lien against the property. 2419 CESM, Daniel Borders.
Jason Rucker, Seminole County Inspector. This is case number 2419 CESM, Daniel Borders, 9 North Stone Gate, Longwood, Florida. Violation, Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permit. This case was originally heard by Special Magistrate on June 13, 2024, and an order was issued giving the respondent a compliance date of August 21, 2024, with a fine of $100 per day to continue to accrue for each day the violation continues or is repeated after August 21, 2024. A compliance hearing is scheduled for September 12, 2024. An affidavit of noncompliance was filed with the clerk on August 22, 2024 after reinspection. Administrative cost for the inspector totals $607.90. The administrative cost for the clerk totals $125.61. The total administrative cost is $733.51. Recommend that Special Magistrate order issue an order constituting a lien in the amount of $2,300 for 23 days of noncompliance from August 21st, 2024 through and including September 12th, 2024 at $100 per day, and a fine shall continue to accrue at $100 per day for each day the violation continues or is repeated after September 12th, 2024. I request that this be entered into record, and that completes my presentation.
I'm going to accept the electronic case file into the record. Alexis, can you confirm that my order of June 13th, 2024 was actually received by the respondent? Okay, so no signed green cards. Was the order posted? Okay. Okay. All right. So I'm going to find that the property owner was properly noticed to be here today for this compliance hearing, and that the property is out of compliance as of October 21st, 2024. So I'm going to ratify my prior order dated June 13th, 2024 for the fine of $100 a day to begin on August 21st, 2024. I'm going to order administrative costs in the amount of $733.51 to be paid within 30 days, and the order can be recorded as a lien against the property. 2430 CESM, Richard and Patricia Rubino.
Jason Rucker, Seminole County Inspector. This is case number 2430 CESM, Richard and Patricia Rubino, located at 1534 Grace Lake Circle, Longwood, Florida. Violation charge is Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by Special Magistrate on May 9th, 2024, and an order was issued giving the respondent a compliance date of September 11th, 2024, with a fine of $50 per day to continue to accrue for each day the violation continues or is repeated after September 12th, 2024. The administrative cost in this case for the clerk was $96.74. The administrative cost for the inspector in this case was $621.29 for a total administrative cost of $718.03. Recommend that the special magistrate issue an order constituting a lien in the amount of $50 for 1 day of noncompliance from September 11th, 2024 through and including September 12th at $50 per day, and the fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after September 12th, 2024. I request that this be submitted into record, and that concludes my presentation.
I'm going to accept the electronic case file into the record. Alexis, can you confirm whether the respondent has received my order dated May 9th, 2024 with a compliance date of September 11th, 2024? Okay, I'm going to find that the green card was in fact received and signed for with this order indicating that a compliance hearing would be scheduled for September 12th, 2024, and the respondent is not here to participate in the hearing. I'm going to find that evidence has been provided that a violation still exists on the property and did as of September 11th, 2024. I'm going to ratify my prior order and impose a fine of $50 a day starting on September 11th, 2024, and accruing each day hereafter until such time as a violation is corrected. I'm going to impose administrative costs in the amount of $718.03 to be paid within 30 days. And last but not least, 2445 CESM, Roger Vega and Catherine Exposito.
Jason Rucker, Seminole County Inspector. This is case number 2445 CESM, Roger Vega and Catherine Exposito at 574 Ruby Court, Maitland. Violation charge is the Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permit. This case was originally heard by Special Magistrate on August 8, 2024, and an order was issued giving the respondents a compliance date of September 11th, 2024, with a meeting scheduled for September 12th, 2024. The administrative cost in this case for the clerk was $106.49. The administrative cost for the inspector in this case was $715.02, totaling an administrative cost of $821.51. We recommend that the special magistrate issue an order constituting a lien in the amount of $200 for 1 day of noncompliance from September 11th, 2024 through and including September 12th, 2024. A $200 per day and a fine shall continue to accrue at $200 per day for each day the violation is continued or is repeated after September 12th, 2024. I would like to submit this into record, and that concludes my presentation.
I'm going to accept the electronic case file into the record. And Alexis, can you please verify that the property owner received my order dated August 8th, 2024? Okay, the order was not signed for, but it was mailed, regular mail and certified mail, and the property was posted. So I'm going to find that the property owner was provided with sufficient notice to be here today for the compliance hearing that was set for September 12th, 2024. I'm going to find that evidence was presented that the violation still remains on the property. I'm
I'm going to ratify my prior order of August 8th, 2024, and impose a fine of $200 a day, starting on September 11th, 2024, and continuing each and every day hereafter until the violation is corrected. I'm going to impose administrative costs in the amount of $821.51 to be paid within 30 days. And that concludes.
Well, ma'am, may I speak?
Oh, yep,
Sorry.
absolutely.
We have currently a vacate pending on this property. A multitude of structures encroach into a utility easement in the rear of the property. I'm going to call it a shed because that's what it was originally, which was converted to an ADU / guest cottage, and then the master bedroom. And then we're not quite sure at this point. So in the advantageous spirit of assisting the planner that's doing the vacate, she needed some history on what was going on with the code case and with the potential variance that's going to have to happen for these structures down the road, because we don't process variances until the vacate is complete, and potential encroachment onto the neighboring property to the rear. I went through to try to find and dig down on what the history was on this property so that we could digest a little bit. And if you don't mind, I'd like to just indulge you, or if you could indulge me for just a moment, to kind of give you some history on this property.
But wait a second, was the building official provided with access to the property? Okay.
Yeah, that's how we got all these pictures of inside. Yes, I met them out there on Wednesday.
Okay.
Last week, and we got all these pictures of the interior, and walked the property with the owner and the contractor involved.
Okay.
So in 2018, which was the last known permit that we have for this property, it was a re-roof that was permitted and completed. And it looks nothing like what the structure looks like now. And I'm going to pass these through because I only made one copy because I forgot to bring down more with me. Then we start in 2020 where the materials start to arrive and the shed structure appears in the rear, along with some additional miscellaneous structures in the rear. And then towards the end of 2020, the rear fence was added, additional roof structures, which becomes the master bedroom addition to the rear of the property, which is the encroachment issue onto the neighboring property. And then a white structure in the northwest corner, which was demolished without a permit. Then we have in 2021, it was kind of stagnant. Construction materials start disappearing, but the structure remains unaltered for about 9 months. Then they added a porch onto the shed structure. The rear pool wall was demoed, the pool cage was partially erected, new vinyl fencing, new pavers on the driveway, a new front porch overhang, shingled roof was placed over the previous aluminum paneled roof on the rear, and those two porch additions that now make the master bedroom. And what was a carport became a garage, which is now living space.
And all of this was part of the original case?
Well, that's why when I started digging down on this, it's why I'm bringing this to your attention, because there may be more violations on top of.
But they haven't been cited?
They have not.
So they need to be? And that would be a new case?
Did we? Okay.
And that would be a new case?
Correct. And then we have new accessory structures. But what I wanted you to see, because this is what's most impressive, is the street views. Those are what it looked like for the majority of the years, and then it ends up looking like a completely different home. And the rest of these are the listing. They evidently had it listed recently, and they're very similar to the photos that you have when you got access to the house.
we cited them for permanent construction because we couldn't get in originally.
It's all of this.
So, and that's all of this. It incorporates everything that they're doing.
Right.
So originally, the violation was correct on permanent construction without permit.
Okay.
So, and that includes all of that.
So if there's anything else, then we need to bring it back as a different case. So right now, I'm going to impose the fine, and it's up to them to,
I just wanted to make you aware because this is going to be part of the part of the variance. So this is going to extend their timeline as to how long, if they come back before you in the future asking for more additional time.
well, they should have been here then,
And
is what I,
And Jay was communicating with them. That's why Jay was here earlier to try to translate for them because she's been working with them directly because they speak Spanish.
When I met with them on Wednesday, I said, you need to be here for the hearing.
and they were here last time, and they brought their own translator, but they spoke some as well. So I'm fine to impose the fine, and then if there is anything additional that needs to be brought back, then we can bring it back as a separate case. All right? That will conclude our cases for today. Our next hearing will be set for October 9th at 1:30 PM. And if that is all, I have approved the minutes, and we have no new business. No one better have any new business. It's too late to have any new business.
This is a long one.
Wow, what a marathon.